Yes.
May I please start? Item number 45.
Item
45. Can it be passed about for the tailor? Because I have a doctor appointment. Well,
45.
yes, doctor.
At a request of Mr. Mazumdar, matter stands passed over to be listed next week.
There is a pending matter may be listed on Friday, my lord.
What is the matter?
Matter relating to the land. Affidavit in opposition and reply already been filed. Your Honor, in earlier occasion, directed to list the matter on after 10 days, but after 1 month, matter has not been listed.
All right, 26th.
26 of life.
Correct the date.
May I please, Lordship? I beg to mention item number 42.
40?
My senior,
42.
42. My senior, Dr. Ankit Todi is out of station.
So you wait.
Yes.
You wait for the matter to be called up. We'll see.
May I
Yes.
please, Lordship, I beg to mention a admission matter for listing.
What matter?
Admission,
Admission matter.
Yes.
What is the matter?
pension relating to pension.
Pension is not before this court. Pension is not before this court.
Of life.
May I please, Lordship, I beg to mention item 44. Lordship, item 44 now interrupts.
44.
Yes, Lordship.
The submission made by learned counsel for the petitioner. Which submits that the matter has become infructuous, the petition stands dismissed as infructuous. Interim orders, if any, stand vacated.
With the consent of the respondent, I beg to mention item number 6 and 7, Your Lordship. Based on adjournment in this matter by 4 weeks.
What happened to that election process?
Lordship, we have directed the concerned authorities to hold the AGM, my lord.
That
Yes,
was in January. What
January.
happened to that?
But
Lordship, part has been done and a part remains, Your Lordship. So by September, the process will be completed.
Completed.
September.
Lordship.
August last.
It is 15 days, Your Lordship, for the AGM and thereafter the board approval, Your Lordship, for another 15 days and approval of the registrar of cooperative societies.
There is some interim order.
No, ma'am. There is no interim order.
At joint request, matter stands adjourned to be listed after 4 weeks.
Can it be in September, Your Lordship?
No. Let it come after 4 weeks. You apprise the court.
My lord. Obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 26, Lordship. In this case, I have received the parawise comment, Lordship. For 3 weeks, I may be granted to file a bill.
Who's for the petitioner?
Yes.
Any objection?
No.
26 at the request of Ms. R. Devi, CGC, matter stands adjourned for 3 weeks, enabling her to file counter affidavit. Counsel for the petitioner, Mr. PM Knox, does not object to the prayer made. Placed after 3 weeks.
May I please, ma'am? I beg to mention item number 25. I am for the respondent. With the consent of the other side, I seek adjournment for 2 weeks.
Why?
Very well.
Why?
Uh,
Why do you want adjournment?
Both the councils have decided and
You wait, you call the council, will hear. Item 25.
Yes, ma'am.
Is submitted by the council of the council for the petitioner. That you are for this, in this matter.
Yes, Lordship. Item 57, Lordship.
Is submitted that the petitioner does not wish to press any further accordingly. The same stands dismissed has not pressed. MSG Hazarika for
This one number 1, Lord.
respondent 1, Mr. Orua for the NHICCI. NHAI. Ms. M. Bormon for and
এইটাতে বেলেগ বেলেগ
With then go to counsel advocate and Mr. P. Gogoi, standing counsel finance, also appears for the response. Sorry? PWP. PWP also appears. Right. If you want to say it is then vacated, pending items are also dismissed. For withdrawal. Any counsel appearing in here in the matter?
No, Lordship, I am appearing in this case for but Lordship, it has already been by this honorable court, the orders which is under challenge here, these have already been taken care of.
Which is the order?
That is at page 58, annexure 12. Sorry, Lordship, it's page 60, annexure 13. Heard Mr. So-and-so, by filing this application under Article 226 of Constitution of India, the petitioner pays for setting aside an order dated 27/7/12 passed by the learned judicial magistrate first class Goalpara, Assam in share case number. This is under challenge, Lordship. The next paragraph, the respondent number 5 had filed an application under section so-and-so protection of was registered as share case number. The aforesaid case was disposed of by the judgment dated so-and-so. This is under challenge and this has already been taken care of, Lordship. Reviewed then, Lordship, as the petitioner. Last paragraph. If we go by the prayer at page 15, the prayer, was the impugned proceeding of the case number CR 1557, that has already been taken care of in the Honorable High Court's order, Lordship. The next one is also, Lordship, same. Third one is also same. Me too, only 1, 2. High Court. 2 and 3.
What has happened to this revision petition? Criminal petition?
Lordship, I have no knowledge. As because the standing counsel High Court will be,
Standing counsel, High Court is there? Yeah.
it should be, Lordship, as because I am appearing for one. Second one is CJM Goalpara. Third one is Munshif number 1 Goalpara. So they are represented by standing counsel High Court.
List this matter on Friday. Showing the name of the standing counsel High Court. The registry will serve a copy on the standing counsel High Court. Will ensure a copy is served on the standing counsel High Court. Copy of this order be brought to the notice of registrar judicial. Mr. H. Sharma appears for respondent number 1.
Lordship,
List on Friday.
Lordship.
Yes,
Lordship, the respondents have not filed any response statement.
yes.
Lordship, I'm appearing on behalf of Corporation Department. In this matter, we are only the formal parties.
Who are the other respondents?
Deputy Commissioner and Director of Food and Civil Supply.
Who is to issue the license? Food and Civil Supply.
FCF.
Who is appearing for Food and Civil Supply?
I'm yet to receive any instructions, Palan. We've written to them. Lordship grants me a week's time.
Heard counsel for the parties, MS Sharma, and government advocate, raised for, and is granted 2 weeks' time to complete her instructions and file necessary affidavit. The matter if so required. Please start 2 weeks.
If you apply.
May it be please, Your Honor. We have filed the additional affidavit as directed on the last occasion. So it may be not in the record because we have filed it today.
When did you file it?
Today only.
It is submitted. No, it has been received. Further additional affidavit.
Yes, for the additional affidavit. It was directed to file documents of contract.
When did you file it?
Today only.
Your name?
Aaron.
MS A. Roy, learned counsel for the petitioner submits that pursuant to liberty granted by the court, an additional affidavit has been filed, bringing on record the conflict document. So the said affidavit, however, has been filed today.
Today.
So accordingly, the matter be listed after a week. The registry will trace out the affidavit, additional affidavit stated to have been filed by the petitioner and connect it to the case reports. List accordingly.
Much obliged.
May it please.
Yes.
Lordship, this writ petition filed against a quashing of impugned order in original dated 27/3/2024, as well as the so-called notice. Matter is relating to the service tax, my lord, and the similar matter is also decided. I have
Forget similar matter. What is your ground? On what basis are you challenging it?
my lord. For that purpose, my lord, may I take your honor, first of all, the legal provisions, legal provisions which is applicable regarding the applicability of the service tax by whom service tax is to be discharged. For that purpose, your honor, kindly peruse the section 68, which I have reproduced in my writ petition, page number 14, my lord.
Yes.
Page number 14, section 68. Payment of service tax. Every person providing taxable service to any person shall pay service tax at the rate specified in section 66 in such manner and within such period as may be prescribed. Subsection 2, my lord, notwithstanding anything contained in subsection 1 in respect of such taxable service as may be notified by the central government in the official gazette, the service tax thereon shall be paid by such person and in such manner as may be prescribed at the rate specified in section 66. And all the provision of this chapter shall apply to such person as if he is the person liable for paying the service tax in relation to such service. Here I want to pose my lord, so far subsection 1 is concerned, this is the general rule that service tax is to be paid by the service provider. Now subsection 2 says it may be paid by any other person as specified by the notification. And for that purpose, Your Honor, may I take Your Honor to notification number 30 of 2012, which I annexed with my writ petition, page number 145, my lord. Page number 145.
Yes.
This is notification number 30 of 2012. I am reading from the second. In exercise of the power conferred by subsection 2 of section 68 of the Finance Act 1994, and in this, and the last part, my lord, the central government hereby notifies the following taxable services and the extent of service tax payable thereon by the person liable to pay service tax for the purpose of the said subsection, namely, and there are certain services were provided. I am on page number 146, my lord, that is 5, Roman 5. Service provided or agreed to be provided by way of renting of motor vehicle designed to carry passenger to any person who is not in similar line of business or this by any individual.
You're reading from which?
Paragraph, page number 146, my lord, Roman 5.
Roman.
Roman 5. There are so many taxable services.
What is the service that you offer?
Renting of vehicles as well as work contract. Two kinds of services. So Roman 5 says provided or agreed to be provided by way of renting of a motor vehicle designed or carry passenger to any person who is not in the similar line of business or supply of manpower for any purpose or service portion of execution of work contract by any individual, HUF or partnership firm, whether registered or not, including the AOP, located in the taxable territory to a business entity registered as body corporate located in the taxable territory. So these are the services. Now, who will pay? That is defined in Roman 2, Your Honor. The one table is given. I am reading the Roman 2, my lord. The extent of service tax in the page number 146 itself. The extent of service tax payable thereon by the person who provides the service and the person who receives the service for taxable service is specified in one shall be as is specified in the following table. Now I am coming to that table, particularly para 7, Your Honor. Para 7 of that table. It is applicable to me. In respect of service provided or agreed to be provided by way of renting of a motor vehicle designed to carry passenger or on abated value to any person who is not engaged in the similar line of business, then the second column is nil. It means service provider is not required to pay tax, but only the 100% is to be payable by the service receiver. And B says, in respect of service provided or agreed to be provided by way of renting of a motor vehicle designed to carry passenger on non-abated value to any person, then 60% is tax is to be payable by the service provider and 40% is to be paid.
Value?
My lord,
Abated value?
abated value, minimized value, Your Honor, like minimized value, like ambulance, etc. That is on the abated value. Now, Your Honor, serial number 9, that is also applicable for me. In respect of services provided or agreed to be provided in service portion in execution of work contract, then 50% tax liability is on the service provider, 50% tax liability is on the service receiver, my lord. And in this case, so far my case is concerned, Your Honor, I have specifically taken the plea that these services are provided to Indian Oil Corporation Limited, and so far renting of motor vehicle is concerned and so far work contract is concerned, 100% tax liability is not on me. And for that purpose, Your Honor, I enclosed one annexer also, that is at page number annexer 13, page 127. Annexer 13, page 127. My lord.
Yes.
This is issued by the Indian Oil Corporation Limited to Prashanta Welding, that is the petitioner, my lord. Please find below mentioned details of service tax deposited under RCM. RCM means, my lord, reverse charge mechanism. That is the term used in the Central Excise Department, reverse charge mechanism by IOCL Digboy Refinery against invoices as mentioned in column C pertaining to work numbers as mentioned in column B along with net payment released to you during the period from 1/4/2017 to 30th June 2017. This is the period, Your Honor, which is disputed in here, 1/4/2017 to 30th June 2017. These are the services they are certifying, that these are the services on which they have paid the tax on RCM, reverse charge mechanism. But this part is completely not given any effect in the order, Your Honor. This is my first submission, Your Honor. Second submission, Your Honor. Second submission, Your Honor. So far, the tax is concerned, Your Honor, service tax, that is applicable only up to 30th June 2017. After 30th June 2017, the service tax was repealed by GST. And so after from 1/7/2017, there is no question of payment of any service tax arise. Now, in this case, what happened, Your Honor? On the basis of Form 26 AS, which is generated under the income tax law, Your Honor, for the entire period of 17-18, they have considered as it up to receive from June 17.
Where is that
Your Honor.
income tax?
Form 26 is at Annexure 1, page 36, my lord.
Yes.
This is the Form 26 AS, and Your Honor, financial year 2017-18. This is for the entire financial year 2017-18.
This is that this reflects the date you receive the payments.
Two dates are there, Your Honor.
Eh?
Transaction date and date of booking.
Right.
Date of booking is the date on which this TDS is given,
Mm.
when this payment is made. And the date of transaction, Your Honor, either the invoice issued or the service rendered, whichever is earlier.
Then why
Two
don't
dates
you-
are there.
All right, very well. Now tell us where is the impugned order?
Impugned order is, Your Honor, at page number 132, Your Honor.
Very well. Come to para number 3.
Para 3.
Yes.
On scrutiny of copy of the audit
No,
report.
page 132, para 3.
Para 3. An appeal against this order shall lie before the Commissioner appeals on payment of 7.5% of the duty demanded where duty and penalty are in dispute or penalty
So
where penalty.
why don't you go in
Agreed,
appeal?
my lord. I am agreed that yes, there is alternative remedies there. I have taken the specific plea also that although alternative remedies there, but since the order is absolutely without jurisdiction,
You urge all this before the appellate authority. Why don't you go before the
My
appellate
lord.
authority?
for that purpose, Your Honor, I have the certain judgment. Since the order itself is a without authority, so this writ is applicable. And moreover, Your Honor, similar case are pending, Your Honor. On the same line, Your Honor.
Similar case may be pending, that's a different issue.
No, my lord.
You have to satisfy the court that this is a matter where the court should not close this matter on the ground of alternative remedy.
Your Honor,
Tell us.
my
judgment
humble submission, since the order is without authority, they are charging the
We'll
tax.
hear on the maintainability. Yes.
Ma'am.
Yes, what do you say?
It is on another court, Lordship.
That besides that, what do you have to say?
Lordship, you have already told that there is an alternative remedy available.
Notice issued. Heard counsel for the petitioner. This petition is filed challenging the interim order dated 27/3/2024, passed by the Commissioner Central Goods and Service Tax, imposing service tax, interest, penalty on the petitioner for services offered for the assessment year. Which assessment year? 17,
April 17 to June 17.
sorry, for the financial year 2017-18. Okay. The grievance of the petitioner is that the service tax as is required the service tax is not required to be paid entirely by the petitioner in terms of the notification. Where is the notification?
Notification is
Dated
notification number 30 of page number 145.
dated notification number 30/2012-ST dated 2006/2012. According to the writ petitioner, in terms of this notification for the services which the writ petitioner has rendered, which is specified at serial number 7 and 9 of the notification, is not required to pay service tax beyond these specified percentage. So that apart, the department has assessed service tax in respect of services which are rendered post July 2017, and therefore the same is required to be challenged. So MS so-and-so appears on behalf of the GST department. So on the question of the impugned order reflects, impugned order itself reflects that there is an appellate authority, appellate forum available to the petitioner to question the impugned order. So let the respondents file their response, if any, and the matter be listed for admission. It be heard on the question of maintainability. Please note, when can you address the court? Matter be listed on 5th of August.
Meanwhile, no court selection.
We are on the question of maintainability. First, submit.
Right.
Tell us.
Okay, in this case, we have already approached the authority by written representation manner that has been accepted now.
So you're not pressing it. Mr. Ordology, the counsel for the petitioner, supports that the
On 1/7/2024.
the grievance of the writ petitioner has been redressed by the respondent authorities on 1/7/2024,
2024.
and therefore it does not wish to press the writ petition any further. This is with regard to the stadium.
Stadium.
Mr. R. Borpuzari appears for the revenue department.
number 3, my lord.
Respondent number 3. Accordingly, writ petition stands with S. Sharma for
1, 2, 4, and 5.
respondent 1, 2, 4, and 5. Accordingly, the writ petition stands dismissed as not pressed.
I'm so obliged.
Any stand negated.
Mr. Kayal was supposed to take instructions on the matter.
Check up for yellow number platform. We'll take it up at 2. Or if you can inform him before the court rises.
Yes.
After a while,
For the time being.
for the time being, yes.
Possible for the time being.
Why? What is the matter?
Let's see.
What is the matter?
Non-mutation of the lane after versus it in the Azara circle revenue.
Will you issue notice?
There's an alternative remedy with a taken approach under the account right to public.
Mr. MCQ election code number 18, so method possible.
All right. Time being.
This matter came up before the vacation bench, and after addressing the court for some time, the matter was since returnable today before the regular bench. If I may draw your lordship's attention to the order of the court, which starts at page number 70.
at page number 17. The effective portion is at page number 18, my lord, at para number 4. If I may be permitted to read para number 4.
Yes.
Upon coming to be informed about the auction called for during the process of liquidation being undertaken in terms of the order of NCLT, petitioner is aggrieved by the fact the reserve price is fairly lower than the price offered by the writ petitioner towards one-time settlement. Being aggrieved, he has approached this court as the forum available to him under the provisions of law, that is NCLT, is stated to be in summer recess and will resume court only from 1st July 24. He submits that as per his instructions, the sale certificate of the auction properties have not been issued as yet, and therefore status quo be directed to be maintained till NCLT passes away orders on the applications proposed to be filed by the petitioner. Upon such submissions being made by Mr. D. Das, Senior Counsel, the learned DHGI was requested to apprise the court about the status of NCLT Guwahati. It was informed that NCLT Guwahati is indeed in summer recess and will resume court from 1st July 24. However, he submits that in case of any urgent matters, an application can be filed before the registry of NCLT. Mr. So-and-so learned counsel appearing for the bank submits that the entire liquidation process, including the auction, has been undertaken in terms of the directions of NCLT, and the same is as per the parameters indicated in the orders itself. The sale certificates in respect of the auction properties have also been issued, and the amount has already been apportioned to the account of the corporate debtor. He submits that under such circumstances, there is no occasion for the writ petitioner to approach this court, more particularly when the appropriate forum is NCLT and not this court. He therefore submits that the writ petition is not maintainable and the same should be dismissed in limine. Learned counsel for the parties represented have been heard. The writ petition has been perused. It is seen that the liquidation process is initiated under orders passed by NCLT for any further grievances of the petitioner arising out of relation to the liquidation process. The appropriate forum is NCLT, although it is submitted by learned DHGI that in case of any urgency, an application may be filed before the registry of NCLT, but there is no clarity as to whether the matters will be taken up by NCLT Guwahati or any other bench during its summer recess on such urgency expressed by the aggrieved parties. Under such circumstances, considering that...
Then what happened?
Yes, my
There
lord.
was a
So there was a stay that was passed by this honorable court. In pursuance to this order, my lord, on 25th of June, on 26th and 27th, there is some trucking movements that happen, which I get to know through my associates. So these trucking movements, my lord, is happening in and out of the factory, and that is where I got apprehensive. At page number 43, if my lord has it, I have in fact annexed a picture at page 43. And this will eventually correlate with the register that has now been impounded. At page 43, my lord will see, this is ML10 C9332. So these movements were happening right after the passing of the order, after the bank being cognizant of the order of the court. And thereafter, I prefer a police complaint, which is at page number 21. At page 21, on 27th of June, so order is 25 June. These movements were happening on 25th, 26th, and 27th. I prefer a police complaint, which my lord will find at page 21, annexure 2. My lord, this is the complaint that I had filed. So more or less the same grievances. My lord, thereafter, the official from PS Bonihart outpost visited the factory premises and impounded the registers. The same was done in the presence of the AR of the petitioner, the writ petitioner that is. Now, most interestingly, my lord will see these registers that were impounded starts at page 27. At page 27, I have in fact highlighted the type copies, annexure 3 collie, page 27. So it starts 12/6, 12th of June. No movements, my lord, for 10 days. Thereafter, the movements happen on 22, 23. Major movements happen on 23. Why I say so? That is when advance service was effected in relation to the writ petitioner before my lord, assailing the entire auction process. That is where in great haste and hurry.
No, these movements are for what purpose?
Yes, my lord, what is happening? If one line I may be permitted to show at page 44, and then I'll come back to my submission at page 44. My lord, the auction took place as a going concern on 6th of June. The publication had happened on 10th of May in the newspapers without actually complying with the 30-day notice period. On 6th of June, they go ahead with the auction, which is a matter that I will challenge eventually before NCLT. Then, my lord, on 10th of June, at around 8:25 in the evening, I received this email from the liquidator at page 44. My lord will just see the first line. and that is where I'll thereafter submit. Dear sir, that this was addressed to the petitioner. This is to inform you that in line with the auction notice published on May 10, 24 for sale as a going concern of Sai Rolling India Limited, an auction was successfully conducted on June 6, 24 from 1 to 3 on the e-auction portal Auction Tiger. So in my most respectful submission, my lord, it was sold off as a going concern. So there is no question of dismantling the plant and machinery and having removed from the CD's premises, factory premises, when there was a status quo order. I have gone to the NCLT in line with the liberty that I had taken before, my lord. But that happened
What-
only on 3rd of July.
What happened in the, what is happening in the NCL?
It is coming up tomorrow. At page 45, I have annexed the first order.
Hmm.
My lord, basis the statement of the learned counsel representing PNB, a statement that was made at bar, some kind of prima facie opinion was taken by NCLT, which is now returnable tomorrow. My lord, at page 45, the last 3 lines, if I may, last 2 lines, in fact,
40?
upon specific query from the bench,
40?
the learned, page
number?
45.
45.
45. This is the order dated 2nd of July.
Hmm.
In line with the liberty that I had taken, my lord will see page 45.
Now you read the whole order?
Okay, I'll read the whole order. I'm so obliged. Learned counsel, Mr. Das, appears physically in the court on behalf of the petitioner. Mr. K.K. Nandi appears on behalf of 1, 2, and 3, accepts notice. 2 weeks time to file reply affidavit. Time granted, copy of reply thereof shall be served on counsel on record of the opposite party. There is no representation for R4, that is the liquidator. The learned counsel appearing for the applicant is directed to issue private notice to R4 by speed post and so and so. Then comes the learned counsel appearing for petitioner, requested for grant of stay, restraining the liquidator from issuing sale certificate to the auction purchaser, contending that the interim protection granted by High Court of Guwahati is getting expired on 3rd July. Upon specific query from the bench, the learned counsel appearing for R123, Mr. So-and-so, made a statement across the bar that the sale certificate has been already issued by the liquidator to the successful bidder who has paid the entire sale consideration. In view of the above statement, this bench did not find any urgency to pass any interim orders. The basis of statement that was made across the bar, the matter is now returnable tomorrow. My lord, the issue of the removal, which in my most respectful submission is a willful and deliberate defiance of the court order, is an issue that in my most respectful submission has to be addressed by this court. My lord, this part of the matter I might not be able to challenge before the learned NCLT. I just put a question to myself,
This
my
is
lord.
a contempt petition you have filed.
Yes, I have filed the content because I am only on the limited issue.
All right.
Yes.
The issue notice heard, Mr. And that's the counsel. Issue notice. Returnable after 3 weeks. Steps on the respondents by usual court registered post AD within 1 week from the list after 3 weeks.
So obliged.
May it please the lordship. In this matter, Mr. J. Hendik is appearing, my lord. He has received some instruction, may be taken up at 2 p.m., my lord.
2 p.m.
Hi, Lord.
If you request the end of the
May it please your lordship. My lord, here in this case, my lord, I have a limited prayer, my lord, that in the name of widening up of the roads, they are going to be taken away the patta land of the petitioner. So my only limited.
we passed some orders, I think yesterday, day before, like that.
Yes, ma'am.
This,
That they have filed representation for demarcation of their portion of land under which that construction is going on, as pleaded in the writ petition, my lord. So in this matter, demarcation is a matter of right to, under the Right to Public Service Act, and there are so many petitioners, my lord. So there must be some individual order regarding that demarcation part, my lord. So they have to apply as per portal, my lord.
No, what order was passed? Last.
My lord,
No, they have taken, they were granted time to
Page
take the
24.
instruction, my.
page 24 kindly say another case with respect to the same construction. I have filed an application that without following due process of law, the land of the petitioner may not be taken away. That was the prayer. And in that case, my lord, notice was issued and government has filed affidavit saying that the construction work was is stayed. So accordingly,
No, this is your patta land.
patta land.
And you are apprehending that.
My patta land may not be taken away
Hmm.
without following due process of law. And if they constructed without touching my land, then I have no objection.
No,
But,
there are two issues here. One is that it is first, is there a question of demarcation?
my lord, question of demarcation will come if they taken away my patta land.
No, but
Prayer
how will
is
they
a
know whether it is a
my
patta
lord.
land or not unless it is demarcated?
That was the prayer made before the deputy commissioner also.
Then
That not unattended.
where
They are
is
going
that?
to
Where is that?
that was made in 2023 February 23. Then thereafter construction was stopped. Now they are again now construction is going on, and in that construction was stopped. That part in earlier writ petition, which was filed by the other petitioner, there says that construction work was stopped. So we will not take away the patta land without the following process of law.
No, no. See, construction is, if it is necessary, it will
I-
have to be carried on.
Carried
You
out.
are only concerned that your patta land should not be
Yes.
taken away
Yes.
without due process of law.
This is only my
Now,
limited.
for that, there has to be a demarcation process.
That is only limited prayer, my lord.
Right? So what is the,
Only limited prayer. I have not.
what steps have you taken for demarcation? Or he says he has filed an application for demarcation. You filed some application.
Yeah.
Where is that?
Representation is filed before the deputy commissioner, my lord.
Where is
but-
that?
Page 22.
22.
5 and 6, and extra page 21 and 22, my.
This is by the petitioners here or some other persons also?
Petitioner.
Petitioner.
And page 21 also. Prior to that also, there was another representation to the deputy commissioner. Then reminder is given on 22 to 23.
We get instructions here and find out.
Yes.
Whether any construction is going on in.
No,
No,
what
construction is going on.
steps have been taken for demarcation. So they have prayed for demarcation. To demarcate their land.
I would like to humbly submit, my lord, because this is an individual plot of land. If demarcation is required for,
So that
My lord.
information has to come from the DC,
my lord.
whether it is individual or their joint pattas or how
Or
they're
as
in
per
possession.
portal, they have to, under the Right to Public Service Act, my lord, they have to apply on the portal, my lord.
Where is that provision? Let us see.
My
That-
lord, regarding that part, my lord, I am submitting that is demarcation between the two patta lands. Here in this case is not between two patta land. Here is the question is between government land and patta land. This is the and in that they are between two patta lands. Suppose there are individuals patta lands are there. We want to demarcate, then that will apply.
Let us see that.
Mutation. Demarcation.
Here in this case is not boundary dispute. It is a dispute between the government land, road and my land.
This is what land? Agriculture.
No, town land. It is in the heart of the town of Filter town. Vivekananda Road. Construction is going on.
If
You get the instructions,
My,
find out what is the issue here. Heard learned counsel for the parties, petitioner is agreed by the fact that the, who is constructing the land,
PWD,
that certain construction for widening of the
Road come drain.
road come drain of the Vivekananda Road in the Silchar town is being undertaken by the PWD Rural Road Division, Silchar. Stop. Petitioners claim to be residents of the area through which the said road passes through, and he is presently under construction or in terms of the NIT loaded and issued by the PWD department. So the petitioners are also residents and owners of a patta land. What is this schedule of your land?
Statement has been given, my lord. At page, paragraph 3, 3, 4, 5, 6, 7. It is with respect to each petitioner. 3 is petitioner number 1. 4 is
The petitioners are owners, holders of the land, more particularly specified the petition, which is extracted as under para 3, 4, 5,
3
3
to
to 10, my lord.
3 to 10.
3 to 10.
Yes,
Yes.
all the petitioner.
Page 6 and 7 of the report.
3 to 10. Correct. The petitioners apprehend that in spite of their representation filed before the competent authority, namely the Deputy Commissioner, Silchar, seeking demarcation of their land through land revenue staff to identify their patta land and demarcate their land from the government land on which the present construction is proposed to be undertaken. So, however, these representations which were filed more than a year back, no steps have been taken. So presently the department, the PWD department has undertaken the construction work, and there is every possibility that the land of the writ petitioners will also be acquired for construction without following the due process of law. Apprehending such, expressing such apprehension, writ petitioners are before this court. MS M. Bormon, government advocate appearing for the respondent.
3, my lord.
3. Will obtain the necessary instructions in the matter. When can you get it?
After 2 weeks, my lord.
Hmm?
2 weeks.
2 weeks. She prays for 2 weeks time to complete her instructions. Let the matter be lifted on 5th of August. Till the next date fixed, the land, the petitioner shall not be dispossessed. Petitioner's land shall not be acquired without following the due process of law.
My lord.
In order to facilitate the government advocate to obtain her instruction, extra copies be furnished within the course of this week.
By today, I
Obliged.
may it please your lordship. Lordship, notice was served upon the respondent, my lord, but till date, no affidavit has been served to us or filed.
You have taken steps
Yes, my lord. They accept notice, my lord.
pursuant to order passed by this court dated 24/3/2023, whereby notices were issued. It's submitted by the learned counsel appearing for the writ petition that steps have been taken, but none represents the respondent. Stop. Let the matter be listed after 2 weeks, office to verify and endorse with regard to the service of notice on the respondents. Let the matter be listed after 2 weeks.
Obliged.
Yes,
And for respondent number 4, most probably, Lordship, their permission has been given, accorded, Lordship, for my instruction, Lordship.
none appears for the writ petitioner, Mr. S.S. Roy, done at CGC.
No, Lordship, respondent number 4.
Appears for respondent number 4, municipal authority. Municipal.
Yes. Since you came in.
Number 4. Namely the chairman, Tinsukia Municipal Board. Matter will be listed next week.
Obliged. Lordship, my name may be reflected in the causal.
Mr. S.S. Names of all councils, including that of Mr.
Signing
S.S. Roy, be reflected in the court by the next.
Obliged.
May it please, Your Lord.
Yes, madam.
This is a contempt application, my lord. May kindly see the order dated last order, my lord, 22nd of March, my lord. The counsel who had appeared, my lord, was asked to get instructions on this. It is basically an eviction matter, my lord. In spite of directions that the petition shall not be evicted, barbed wires may put fencing, my lord. If I may just give a glimpse of, my lord, at page 95, 93 and page 102. It's a series, my lord, that this is the condition what they did in spite of the interim order. And that is why when this contempt was moved, the council was,
Who's for the council? Mr. Nath will appear.
I am appearing on behalf of Mr. D. Nath, Lordship, for
Yes.
respondent numbers 2 and 3. Lordship, in the main case, Lordship, in the WPC, the government has already filed an affidavit, Lordship.
just now we are on the contempt, my lord. In this matter, the government was asked, the council appearing was asked to get instruction.
Ingress, outgress to weapon as in the block for it.
There is no direction for him to. Okay, Mr. Nath had prayed for obtaining instruction.
Lordship. Lordship, in the writ petition and affidavit. has been
Whatever it
filed,
may be, we
Lordship.
are going through this order. Do you have a copy of this order?
No, Lordship.
You please have a look at this order.
At 2, Lordship.
Yeah, at 2.
Well,
Why at 2? Just have a look. Have a look just now.
I'll just show it nowadays with the convenience we have. Just
We are making it more convenient. We are handing over the file. Have a look at the order.
2/3/23. Thank you. Oh, Bob, I better go. Kept open for ingress and outgress of those still residing inside the scheduled line. Contempt to learn. As I'm informed, Lordship, those they are not being evicted. as of now, Lordship. And the ingress and outgress road that has been kept open.
So you refer to the affidavit, therefore we pointed out the order. The order permitted the government advocate to obtain instruction. So
Lordship,
if there are any instructions you may like to place it before the court.
Lordship. The affidavit is already on record, Lordship. No?
Why can't you just tell us what instructions are there?
In the writ petition, Lordship, there is an affidavit.
Stopping ingress and outgress.
Just one part, my lord, at page 102, if my lord can see that this is the situation they had created, my lord. Like there's something like kind of inhuman.
Affidavit filed on 20th of May. Which affidavit?
Yes, Lordship, 28 of
25, 2024, Lordship.
What is the stand here? What have you stated?
Lordship, it is reflected in Roman 5, Lordship, page number 794. Has your Lordship got it?
Yes.
That the deponent begs to state that the writ petitioners, by filing the instant writ petition, have assailed the eviction notices dated so and so. In view of the fact that the petitioners are encroachers upon the government land, the respondents had to carry out the eviction drive on 3/9/2022, that is much prior to the filing of the writ petition, for evicting the petitioners along with other persons from the government land under their occupation. Pursuant to the orders dated 21/12/2022 and 2/3/2023 passed by this Honorable Court in the instant writ petition, the status quo has been maintained and no further eviction drives were carried out for evicting the encroachers from the government land in question. The next para is important, Lordship. That furthermore, the deponent begs to state that as per preliminary information, most of the petitioners in instant case are not landless individuals, as they possess periodic annual patta land, other private land in the village spreading across Sonitpur district and other neighboring districts as well. A detailed inquiry would be necessary to actually ascertain the landless status of the petitioners, and the same could not be carried out as the matter was sub judice before this Honorable Court. A total of 299 families were evicted on 3/9/2023, and out of those, 45 families were found to be.
So pursuant to this order, this affidavit is on record.
Lordship.
So if you
In the on merits, which I have filed a reply and I have denied what they said. And in this content, my lord, it is
you
necessary.
filed a reply
Yes.
in response to this affidavit.
Affidavit or reply one again to
No, my lord, I have not filed a reply to that.
You file your reply. We'll take up both the matters together.
Lordship.
Well, let them also respond to the content, my
You've
lord.
already filed.
In the writ petition,
We'll
they
take
have
it up
filed.
together.
My lord.
Take it up together.
My lord.
Why are you pressing for the contempt?
Oh.
Contempt is between us and them.
That is correct. my
You
lord.
are insignificant. I'm sorry to say.
Okay, very well, my
Between
lord.
us and
If
them,
the court
we'll
is-
decide whether the order has been violated or not.
Correct.
Now, whether you have a case or your rights have been infringed upon, they have already filed an affidavit.
To this, I will respond, my lord. What I am trying to point out, my lord, if I am correctly pointed out that it's the contempt is between the court and the alleged contemner. What I am trying to point out, my lord, that there being a specific order, they did the violation, and thereafter,
Therefore, you file your response. We will hear. We'll also decide the contempt. If there is a violation, we
I will do that.
take them to task.
I will do that.
Rest assured.
I will do that, my lord.
Heard. Learned counsel for the parties. Learned counsel for the petitioner has pointed out the order dated 22/03/2024 passed in contempt case 138/2024. Stopped by the said order, the learned senior government advocate was permitted to obtain stop. Counsel representing the senior government advocate has informed the court that an affidavit reflecting the contesting the averments made in the writ petition has been filed by the Deputy Commissioner,
Deputy Commissioner.
Sunitpur.
Sonitpur.
So, and the instructions which the affidavit is prepared is being filed on the basis of the instructions received by the senior government. So, she therefore submits that let both the matters be taken up together. Para. Ms. Goel, learned counsel appearing for the petitioner, submits that she would like, you want to file a response?
We would have, my lord, because of that situation, my lord,
Submits that you'd like to file a rejoinder to the affidavit filed by the respondents. He therefore craves leave, prays for some time for filing the affidavit. List after, tell us,
after about 4 weeks, my lord.
submit that matter be listed after 4 weeks, then you are to file the rejoinder. Accordingly, let the matter be listed after 4 weeks. Let both the matters be listed after 4 weeks.
I'm great.
And in the contempt, are you required to file anything? Respondents in the contempt are at liberty to file their response, if any. So, if so advised, I mean,
I'm great.
The 17 and 37 are connected matters, my lord. This is that sale of the two tea gardens, my lord, auction by the PF authority. For them to inform, my lord, whether any auction has been successful or not.
who is to inform?
No, the PF authority.
Who is for the PF?
Because Mr. R. Sharma and Ms. G. Goswami had appeared on the last occasion. I've seen them.
My lord, counsel, Mr. B. Gogoi is on legs in court number 17, my lord.
B. Gogoi?
He's for ATCL,
ATCL, my lord.
respond number 2, my lord.
Yes. What happened? The auction took place.
My lord, I think
They perhaps
He'll be
may not,
appearing with
may
him.
not be knowing. It's really, my lord, the
These are instructions you should have. Merely appearing and asking for a passover, passing by, time over, adjournment.
we had also contacted the learned counsel for forensics, but say no instruction.
Call it up. We'll call it up after a while.
My lord,
You inform them to get instructions what happened to the auction.
my lord.
Lordship, in this matter, affidavit is ready and sent for vetting, Lordship. Kindly grant 2 weeks time, Lordship.
Aadhaar,
Aadhaar
not
card,
granted.
not granted.
my family members of all family members.
2 weeks is a long time. File
Yes,
in
Lordship.
1 week.
Yes, Lordship. And it is sent for vetting, Lordship. Not,
Vetting is between you and your client. We are not.
yes, Lordship.
You file it within 1 week.
Yes, Lordship.
Date may be fixed.
It is submitted by the respondent that the affidavit is under preparation and likely to be filed shortly. She prays for 2 weeks further time. Mr. Gwala appears for the submits that there is an urgency in the matter. Accordingly, matter be listed after 10 days on a date to be fixed by the registry. The respondents may file their affidavit if so advised in the meantime. After 10 days on a date to be fixed by the registry.
It is very difficult to list it.
Very difficult. What is the difficulty faced?
Because my lord, application, my lord, filed before the registry, my lord, for listing, my lord.
Mention doesn't work.
Mention.
July.
Obliged, my
29th July. 90.
My lord, in this matter, we are going to file our affidavit today itself, my lord. So matter may come up either Monday or Tuesday, my lord.
It is submitted by Mr. S. Das, Learned Standing Counsel. I can see that the affidavit is likely to be filed today. He submits that the matter be taken up on twenty-second. You want on 24th.
My lord.
24th. List again on 24th. Mr. Polita for respondent number 1.
Highly obliged.
Petition, no affidavit has been filed as the respondent.
Who's for the respondent? Income tax. Mr. KL. We were searching for you since morning.
Lordship, I was in court number 1, Lordship. The matters were fixed there. Lordship, this matter may be taken on Tuesday. I have already sent, probably it will be resolved by Tuesday, Lord.
Right, Tuesday. Tuesday will be 23rd.
23rd, Lord.
As requested for by the study council.
Any other date than 23rd? Lordship, any other date than 25th? 25th. Okay, 25th.
24th. It will be listed on 24th. A joint request. 24th.
Deeply open.
Lordship, with respect to item number 11.
Yes, yes.
Actually, I escaped my notice because my name was not shown. Matter will be resolved by maybe fixed on 23rd. I would, because some other matters relating to similar matter were disposed by this honorable court. Only if the department is to pass an order. Probably by day after tomorrow or by Monday they will pass necessary order.
We'll keep it on 24th then.
No.
Item number 11.
11.
It is submitted by Mr. SCKR, Learned Standing Counsel. GST.
Yes.
That CGST. That the matter is under active consideration by the department and some order is likely to be passed within this week. Therefore, submit the matter be listed next week. Mr. P.D. Das, Senior Counsel, assisted by Mr. Foxen. You're Mr. Lotha. Lotha does not object to the prayer made. Accordingly, as agreed to by both councils, let the matter be listed on 24th of July.
Much.
Lordship, final petition is for enhanced amount of the ex-officio benefit not when the family member died in extremely attached, Lordship, on basis of the notification, Lordship, Annex C, page number 35, Lordship, we are claiming. Lordship. 1 lakh rupees is already provided to the petitioner, family member of the petitioner, Lordship.
No, what has been provided?
1 lakh is already granted to us.
Then how much are you paying for?
Enhanced amount up to rupees 3 lakh, Lordship. Now remaining 2 lakh, Lordship, we are claiming. Is a joint petition, Lordship.
Yes. Revenue.
I'm for the state,
State. What do you say?
Lordship, my lord, that he, as per the last order, Lordship, kindly see the order to a specific order. He has not been annexed, my lord, any documents regarding, my lord, that the payment of, my lord, that receive of the.
So you examine and find out.
Lordship, this letter about
or you tell us whether he is at all entitled to the enhanced amount.
Lord, that instruction I don't receive till now.
You show us from the pleadings when have you received that amount? When did the incident take place?
Lordship,
That is also not specific.
When did the incident take place?
Actually, Lordship, the Number of petitioners have filed this present petition, Lordship. There is no specifically mention, I admit, Lordship.
Then-
So in the meantime, Lordship, allow me to withdraw and file liberty, Lordship, file individual petition.
Learned counsel for the petitioner submits that there are certain facts which are required to be, which ought to have been incorporated in the writ petition. However, the same were not that, he therefore seeks liberty to withdraw present writ petition and file a fresh if the need so arise. Accordingly, writ petition stands withdrawn. With liberty. He is dismissed as withdrawn with liberty. Mr. J. Henry for respondent number.
Lordship, state correspondence. Respondent number 1, 1, 3, and 5, Lord. 1, 3, 5, and 6. Lord.
1, 3, 5, and 6, MS G. Hazarika for respondent number 2.
Obliged.
Interim orders, if any, stands vacated.
Release with the non-payment of.
But some time is required to obtain the instruction, Lordship. We have not received the instruction.
Non-payment
Manner.
in terms of Kamsher
Under that also will do, let them take the instruction, what they say specifically, manner.
So if that does, then we will, if that will do, then we will close it. Why wait for instruction?
Lordship can dispose of it.
Kamsher
That will do, my lord, but
All right.
culturally is the not time limit is there. That is the problem.
when was the works completed?
My lord, at page 23, my lord. And bill submitted as page 29.
Two 2015.
My lord, 15 matter, my lord, but bill we have submitted, they have lastly communicated, my lord, at page 75.
Where is the admission?
Admission page 75.
This is by which department?
Public Health Engineering Department.
Okay, let them get their instructions. Learned counsel appearing in public health engineering submits praise for 2 weeks other time to complete the instruction. Mr. J.R. Boy Bhuiyan, counsel appears. Petitioner is after 2 weeks.
So date may be fixed any day 2 weeks.
8th of August.
Obliged.
Yes.
May I present? My lord, this matter list, my lord, non-payment of contract amount, my lord. The admission, my lord, is.
Where is that?
Page,
Where
my-
is the contract? Where is the work order?
Page, my lord. Page 15, my lord.
Yes.
Lordship, if I may, Lordship, this case has come after a long time. I believe the last listing was on the month of March of 2023. Lordship,
Therefore, no further time.
Lordship, may give us some time. We need our up-to-date instructions, Lordship.
My lord, may I pray, my lord, we may be disposed of in terms
So,
of my lord.
so first tell us where is the work order?
Whatever, my lord. There's probably, my lord.
You have submitted bills, no doubt, but we must be allotted some work order.
My lord, I'll file them, my lord, additional activity, my lord.
Better you give them some time to obtain
My lord, my lord.
instruction.
Lordship.
Just after 2 weeks.
Like, date me, please, my lord.
No. Let them get instructions first. You don't have information here. What is the point in fixing dates? The standing council will obtain instructions in respect of the matter. And Mr. Counsel, Raman, counsel for the petitioner, is also given liberty to file additional affidavit to bring on record, if so advised. Yes.
Much obliged, Lordship.
Mr. Roman.
May I please, lordship? This matter arising out of land acquisition case. Some lands were acquired. Lands were acquired, and it is admitted that I have the title over the land, but I have not been given any share of the compensation. Accordingly, I made an application before the land acquisition officer, and the order has been passed rejecting my claim, lordship, at page 29. Paragraph 7, if I may read out. Whereas during the hearing, page 29. Next. Whereas during the hearing, it came to the light that the dag and patta in question was mutilated in favor of the legal heir of late Jumar Ali, including the name of the complainant and respondent. The complainant and the respondent had mutual understanding earlier, hence they enjoyed their inherited property as per their position. During the hearing, the respondent cited 4 numbers of documents reflecting their share of the dags on mutual understanding. On perusal of the cited documents, it reflects that the share of the complainant was handed over in favor of the respondent after monetary transaction by the complainant, and on the strength of these documents and handing over the possession, the respondent has been enjoying undisputed possession over the acquired land. It is a fact that the name of the complainant was also mutated as a Popatadar, but the portion of the land acquired for Assam Mala project was in possession of the Ataur Rahman respondent as a fishing ground since long back. Land revenue receipts were also submitted by the respondent. After receipt of complainant, ADC, LA, and physical verification of the land in question, along with Gao Pradhan and concerned Latmandal, LM, and random inspection was made in this respect to the villages when it was found that the land in question has been in possession of Ataur Rahman since long, and thus that during the hearing, the complainant failed to establish his position over the land in question. So my claim was declined, lordship. But the law is that when there is a dispute, lordship, title it has to be referred to the reference court.
Lordship, I am appearing for respondent number 5, my lord. So, my lord, 1 week time may be granted, my lord, to file a review petition. But first time I am appearing.
Where is the earlier sanction order?
Sanction order, I do not have lordship sanction order, but it is admitted that they have received it. And in this impugned order, paragraph 3, it is written, lordship. Whereas after sanction of compensation,
they merely say that you are in possession.
No, they are saying I am not in possession, but I have title.
Where?
In paragraph 7, lordship.
No. In you are referring to the order at page 29.
29, lordship.
Then which paragraph?
Paragraph 7, lordship. 1, 2, 3, 4, 5, 6, 7.
Yes.
Whereas during the hearing, it came into light that the dag and patta in question was mutilated in favor of the legal heir of late Jumar Ali, including the name of the complainant and respondent.
Who is the complainant?
Myself, lordship.
And who is the respondent?
Respondent, my brother's, my brother. In my application, I have categorically stated that there is no partition. I did never deliver any position, etc. So there is dispute regarding this. So land acquisition officer cannot decide this issue. When a title is admitted by the land acquisition himself, it has to be referred.
Yes. Now you are appearing for
For respondent five.
5.
One time again.
Who is respondent 5?
The private respondent.
Private respondent.
How are you affected?
No, they have got the compensation. Compensation is their favor.
From the land which is under your possession.
No, I have title. They are saying that it is under their possession.
Oh.
So there is dispute regarding possession, but my title is there.
I'll file my affidavit in opposition.
All right. Mr. Talukar, anything? Any instruction?
No, I have not received any instruction, but my lord, let him file the security bill, my lord. If there is a dispute regarding the apportionment, my lord, then it has to be referred to.
Right. Third Joint Counsel for the party. The counsel appearing for Mr. K. Ahmed, counsel appearing for respondent number 5.
K. Bhuyar.
K. Bhuyar, sorry. Submits that he would like to file an affidavit and pray for 2 weeks' time. Prayer made is not objected. Accordingly, matter be listed after.
I love that. Problem.
List again after 2 weeks.
May please your lordship. It's an arbitration petition, my lord. The last occasion, respondent has taken time to file their affidavit.
My lord, the affidavit is ready. We've sent it, my lord. We're just waiting because the respondent is in Bangalore. I think we yet to receive a signed copy, my lord.
Counsel for the respondent prays for further time to file the affidavit. Prayer made, it's not disputed, taken by the counsel for the petitioner. The respondent prays for 3 weeks' time.
2 weeks, my lord.
2 weeks' time. List the matter after 2 weeks.
I'm deeply aware.
I'm deeply aware.
Yes.
Wait, please, your lordship. Lordship, I'm praying for 2 weeks' time more to file my objection, your lordship.
Similar prayer. List after 2 weeks.
Kindly pass over the matter for the timing.
Right?
Lordship, my senior is on late at port number 1, your lordship.
And lordship, we are awaiting instruction in this case.
They are awaiting instruction.
Lordship, but there is a issue notice on stay prayer which will be considered on the returnable date, your lordship.
All right.
That may be reflected.
Second half. After 2.
Oblige.
Same. At 2 p.m.
No, lordship, this may be.
They are not connected matters.
They are not connected.
No.
Instructions are awaited.
Matter be listed after 3 weeks, enabling the government advocate to obtain instructions and file necessary affidavit to advise. Counsel for the petitioner does not obtain prayer fee. Based after 3 weeks. Yes.
In this matter, my lord, I have to obtain instruction regarding publication of that rule, my lord. That legislative department has responded, my lord. They say that in so far as acts are concerned, it is notified, but so far as rule is concerned, it is the administrative department who have made that, who will make the rule and they will rectify.
So no rule.
So apparently from this, no rule.
And why is the rule necessary? Some order has been passed in terms of the rules.
Yes, impugn order has been passed in terms of this rule, my lord.
Where is that rule? Where is that impugned order?
Is 39, my lord. It
Huh?
is the deduction, my lord, to the
39.
my lord. And is 40, my lord, whereby the payment was cheated. Is 39, my lord. This was issued by the of the district commissioner, my lord.
So who is the administrative department here?
Matter relates to environment, my lord, probably it's either forest or pollution control board, it's a statutory board, my lord, environment. Forest
You
and
are the
environment,
government, you don't know who is supposed to make the rules.
it
Who
is
is
not
the
reflected.
administrative department here?
It will be forest, my lord.
Who has sealed it?
My lord.
The pollution control is under which department?
The environment and forest.
Environment and forest, my lord.
Statutory board, but administrative control of environment and forest.
Where is the forest council for forest?
In fact,
They are not party.
Yes, tell us.
this is the guideline which has been issued by the board for the internal guidelines of all the officials who deal with matters related to brick clean. So this guideline has been issued on 12/6/2013. So immediately after this guideline, the same thing has been reflected in the website.
Yes, yes,
So-
Mr. Gogoi.
There is no such.
There is never been a more appropriate time for you to make a claim. You're looking for the forest council.
Yesterday I had consulted myself.
This I have to take some written instructions because the environment pollution, the air pollution act.
This is what I like about you. You know the matter, although you are not a party. We thought we'll implement the forest department as the party.
Yes, well, I have to take some written instructions, whether it was gazetted or not.
The legislative department says they have no idea. They have left it to the administrative department, and rightly so, because rules are to be prepared by the administrative department. Sorry, Mr. Borua, you are submitting something.
So there was a guideline which has been issued by the board for the internal management of all issues relating to establishments and subsequent functioning of the brick clean. So this guideline has been issued by the board for the use of the officials who deal with the brick clean issues. So this was 2013. Thereafter, the Government of India, Ministry of Environment and Forest, they have issued another notification whereby some.
You see the impugned order.
Impugned order
refers to the rules.
It refers to the rule, but in my humble opinion, there is no such rule which has been legislated.
Then, prima facie, this appears to be totally without any jurisdiction. Yes, Mr. Gogoi, please get instruction.
I'll take it. My lord, petitioner is suffering from huge loss, my lord. A huge investment, my lord.
No, huge investment is all right. You have to.
My lord, my lord.
Petitioner is suffering, my neighbors are getting
wait for a few more days.
It is not
Let
it
us see.
operating, my lord. It operating করবে জানে ভাই।
Mr. M. Bormon, learned government advocate, has apprised this court on the basis of instructions received from the legislative department government of Assam that insofar as the what is the act? Assam Brick Clean Establishment Act.
Rules, my lord.
No, you said the act is published.
No, usually it's a general statement, my lord, without
Submits-
referring to any act, my lord.
Submits that insofar as
Acts are
rules are
usually
concerned, is
notified
the
by the
administrative department which is required to prepare and publish the rules. Therefore, the administrative department, in this case, the forest department, who is required to apprise the court as to whether the rules, Assam Brick Kiln Establishment Regulation Rules 2013 was
Gazette notified.
Gazette notified. Stop. Mr. D. Gogoi, learned counsel appearing to the forest, submits that since forest is the administrative department under which the pollution control board is the administrative department of the pollution control board. Therefore, he is like to obtain instruction, apprise the court as to whether
Malad, we are not a party responding to that also.
Whether the forest department is whether the rules have been gathered notified by the administrative department. So, since the forest department, government of Assam, is not related party, that the commissioner, what do you say, commissioner and secretary?
Commissioner Secretary.
Department of Forests, government of Assam, we are it is party responsible. So registry will make necessary endorsement. Writ petitioner will file amended course title reflecting Forest and Department of Forest, represented by Commissioner Secretary Government of Assam as respondent number 5. The amended course title will file before the registry within 1 week. Within 1 week. Extra copies of the writ petition be furnished to Mr. Gogoi during the course of the week, enabling him to obtain instruction. 5th of August.
May it please the Lord. The affidavit from the respondents are
Awaited.
they are yet to file the affidavit.
Yes.
Lordship, he's on legs.
How much time do you require?
Lordship, matter may be fixed tomorrow.
Tomorrow. We are giving you 2 weeks time. Let the matter be listed after 2 weeks, enabling the respondent to file the affidavit. Mr. P. Das appears for the writ petition. It on 5th of August. Till the next 8 weeks, interim order passed will continue. 5th August.
They are supposed to file the affidavit line.
Yes. No affidavit. When can you file it?
Lordship, 2 weeks time may be given, we will file everything.
2 weeks. Further time it has prayed for is granted. What is the issue? Same cases. When was the other matter fixed? The earlier.
5 August.
5 August. So we'll list it on 5th. List this matter on 5th of
That my lord, the interim prayer may be considered.
Prayer for interim as well as I think the
Maintenance
maintenance is also
both
open.
Much open.
Will be considered by the court. Prayer for interim as well as question of maintenance. Yes.
My lord, I'm praying for further 3 weeks to file it.
3 weeks.
Lot.
3 weeks.
Lordship.
What is your grievance? Delay condonation.
I'm praying for the condemnation of delay in filing the ITL. There is a delay of 15 days.
See, there is a prayer for interim.
Lordship, otherwise, Lordship, the power of the condonation of delay that is vested with the my lord board, and he has not approached the board, my lord. He has approached the my lord the commissioner. My lord, because my lord section 119, my lord.
You get it by next week.
Lordship.
Let the matter be listed again on 29 July.
I have some 29 July.
Lordship.
29 July.
Lord, deeply aware.
Enabling the standing council, subject department to complete this instruction in the matter.
I'm
Mr. Khan.
MD Khan.
MD Khan appears for the writ. Yes.
Similar.
Similar. Same order.
Because 35 and 36, we received parawise instructions, we'll file affidavit 2 weeks. Interim assessment.
Mr. T. Council representing the excise department submits their instructions have been received. They'd like to file affidavit in the matter. Mr. Chaudhary, Ken Chaudhary, Senior Counsel, assisted by Mr. M.
Well, we will be given 1 week further time. We'll file a reply, then the matter may be listed.
He does not object to the prayer made. Accordingly, let the matter be listed after 3 weeks.
3 weeks.
Enabling the respondents to file their affidavit within 2 weeks as prayed for, and a further week's time to file the rejoinder, if so advised.
Well, interim orders will continue.
Interim orders will continue until further order.
Deep level.
The same matter connected with item 17.
We ordered that at 2 p.m. is it?
Lordship had not said so. Lordship said after some time.
Already at 2 p.m.
Okay.
What was the other item number?
Item 17.
1700. Yes.
May it please the Lordship, this is appointment of arbitrator. The arbitrator has been already been appointed and he has given, and the arbitrator has already given his consent.
Yes.
And we have already filed an affidavit, my lord. To that effect. 17 and 18. Both one. So my lord may close.
What is to be decided here?
Yes, my lord, nothing is left to decide. Only the confirmation was, we were supposed to file the confirmation.
Have you filed it here?
Yes, yes, my lord. It's there on record.
Yeah. Billy. Pasu. And hard to win like only.
Heard done it down to the parties. It submitted that pursuant to the order dated 15/5/2024 passed by this court, whereby Justice B.D. Agarwal of the second time, former judge, this the Guwahati High Court, was nominated as an arbitrator, and the petitioner was directed to take necessary steps and from the it is submitted by the learned counsel to the applicant petitioner that an affidavit that effect has been filed on 1st of June 2024 is available in the case report. It submits that the learned arbitrator has already expressed his consent, has given his consent for undertaking the dispute for redressing the disputes as an arbitrator between the parties. The copy of the consent that includes as an extra 4 will say additional affidavit. Stop. Copies of the affidavit has also been received by the council forest department. Since the learned arbitrator has expressed consent pursuant to the order passed by order dated 15/5/2024 passed by this court, nothing further needs to be decided. The learned arbitrator is requested to proceed in the matter expeditiously.
My lord, my lord may direct us to appear before him on a particular day.
The parties will appear before the arbitrator on, you give us a date.
Eighth August. 10th August.
No, for the first date, let it be a weekday.
Yes, madam. Then it should be, let it be on 9th, madam.
9th of August. Will appear before the parties. Will appear before the learned arbitrator appointed on 9th of August. Is the copy of the order required to be communicated? No.
My lord, we have already communicated as per the last order. We will communicate this order also. We'll also communicate this.
The parties will communicate the copy of the order to the learned arbitrator. The arbitration petition according to that close in terms of last date.
Same, 18 of, next segment, same. 17, 18,
38 and 39.
39, my lord, 39, same.
Same order.
Same order.
Who is the arbitrator?
Same.
Same arbitrator.
Same order. The same dispute, the two contracts, man.
All right.
Two different lot. Much obliged, man.
All right. There also you have filed an affidavit.
Yes, my lord.
Is given a
It
contract.
is there, it is there. 18.
To sign. Yeah.
Same, my lord, even they have received the copy.
All right.
Much obliged, man. Please,
yes.
The issue revolves in this present case regarding the running of a LPG distributorship in the name and style of Pratima Gas Agency. Your Lordship, there is an agreement executed between me and the respondent. Your Lordship may find in page number 17. 17 of the petition. Agreement dated 4/6/2018.
Page number?
17, Annexure 2.
Yes.
Lordship, the respondent here is the first party and I am the second party in this. Lordship, in page number 18, paragraph 3, I'll read it out, Lordship. And whereas the first
This
part,
application is for what? Appointment of an arbitrator?
yes, sir.
So show us the arbitration clause.
Lordship, page number 22. Page number 22, paragraph 22.
Yes, okay. Then
Your Lordship.
what happened after that?
Lordship, firstly, the respondent had approached me to run the distributorship of LP.
We are not deciding that correctness of the contract or anything. We are to, this is an application under 11(6).
Yes. Lordship,
tell us what happened.
We have invoked section 11 of the Arbitration
Where is the
Conciliation Act.
notice? Where is the notice?
Notice is on page number 28, Lordship, Annexure 5.
Yes.
Lordship, we have prayed for, we have sent a letter to respondent for appointment of the sole arbitrator and we have sent him through post also. Page number 32 is the postal receipt and 33 is the track report which clearly says that he has received the same.
You have not received the notice.
Lordship, we have received the notice. After that, the respondent, as per he instructed us, he has informed the petitioner is because in this agreement, it is for a LPG distribution. But sir, the commercial agreement with the BPCL, this is the company which has leased us the license, they have clearly stated that we cannot sublet or lease to any other person. And in this arbitration, we think that without the company being the party, the exercise would be a very futile exercise because I have filed an affidavit in opposition in which page number 63. Your Lordship, you may kindly.
Lordship, there is
page number 63. Sir, clause 21, sir. So we are not empowered to sublet or create any interest with any third party.
Why did you enter into an agreement?
Your lordship, at that time, the parties might not have the knowledge of the same. And sir, we have, after that, we have also entered into a deed of partnership. All those materials have been concealed.
Yes. So you are saying that the dispute is not arbitrable?
Without the company being the party to this dispute, it's not arbitrable.
Your lordship, my agreement is with the respondent only, and the issue is with the respondent regarding the settlement of claims between us. So the matter may be looked up by in the arbitral proceeding, lordship.
Because
and he has not denied that there is a dispute. There is a dispute between.
There is a dispute, your lordship, but the exercise will be very futile because BPCL, the company, should have been made party. The consequence of that, we have also entered into a deed of partnership after the agreement. Those facts have been concealed in this petition.
Lordship, the agreement between has been executed only between us and not between parties. So my engagement is only with the respondent and not with the company concerned. I have no business with the company.
Item is sold of the company.
And my agreement has also not been terminated.
You are only to operate. It's not for further distribution.
So here in the
page 13.
So page 13 also 60. So the commercial license distributorship agreement I'm referring to, sir. Page 63 of the.
No, but what is page 13? This is the agreement.
Page 30 is the notice. Or 13.
13. What is this? This is the agreement.
This is the initial temporary agreement which was being done between us, and after the expiry of this agreement, we had done another deed of agreement between us. Page number 13 is the temporary agreement.
All right, come to page number 18 then.
Lordship, this is the subsequent agreement, and
so the fourth paragraph. This is an agreement to operate, run, and function.
Yes, your lordship. Sir, your lordship, that is also not been entertained by the company to operate. Lordship, affidavit in opposition, page number 64. Domestic commercial agreement between me and the.
You are referring to page number 21, clause number 21, page 63.
No, after next page, 64.
Yes, 64.
C1, the distributor shall not enter into any agreement, contract, or understanding whereby the operation of the distributor.
Operation of the distributor and operating it on a day-to-day basis are different. You are just assigning him the reason to operate it. You are in charge.
We have contacted the BPCL. They are not. So we, after the agreement and the partnership deed, we have entered into with the second party, with the petitioner. We have contacted the company. They have said they will not be, they will not agree to this.
They will not agree. It is your fault. You have entered into an agreement. Why have you entered into an agreement? You have not filed an application before appropriate forum for cancellation of the agreement.
We are contemplating to that, but in the meantime, they have filed this petition.
They will file. The agreement is only to operate.
Yes, sir.
Then how is this clause coming in the way?
Because they have operations. operation of the distributorship, we cannot sublet it to the any third party or firm.
You filed your affidavit.
In opposition. Yes, Your Honor.
What is your stand here?
So that we cannot sublet it or
No, you cannot sublet it, then why did you enter into an agreement?
that the party was not.
Then what steps have you taken to rectify it? You can't say that I have entered into an agreement not conceived of by the parent agreement. Yes.
After the agreement, only the things have been disclosed by the.
So under now you have to decide this issue.
But that's what, sir, the arbitration proceeding would be. So the result of the arbitration proceeding would be very. The exercise would be very futile, sir.
No, why futile? Under what provision are you saying that this is not permissible? According to us, it doesn't appear to be. From a plain reading of your agreement with the IOCL, it doesn't appear to be that there is a bar. Knowing fully well you have entered into an agreement. Now you don't want to honor this agreement. And you are finding ways and means to get out.
Because we thought that the BPCL should have been made party.
Not necessary. Why should the BPCL be made a party? You file an application if this is your round. You file an application.
Okay, sir, we'll file. Give me, sir, 2 weeks time.
List the matter after 2 weeks, enabling the respondent to take steps to file necessary application to advise for the court making appropriate prayer. Mr.
G. Kaushik.
The court, yes. Sorry, the application. Yes. Let us decide on this. Finally.
Obliged.
41 Maladel Peru's order dated 22/5/85. The earlier set of councillors withdrawn.
None appears for the writ petition on court by earlier order dated 8/5/2024. None represented the writ petition on court. The court permitted. None had also appeared before the court on 8/5/2024 and 25/2024. Although the way we also with the matter court of none appeared before the prosecution. Interim orders, if any, are vacated, and pending eyes are.
Always.
May I please your lordship, my senior for the
You argue.
Yes.
You argue this matter.
Sir, I'm not instructed to argue.
We are directing you to argue. We are permitting you to argue. You don't require instructions when you appear before the court. We are permitting you to argue. You prepare. We'll take it up day after.
Yep.
Day after tomorrow.
Most appreciated.
What is your name?
Arguably.
Miss
Arguably.
Arjuti. Learned counsel appears for the petition submits that she will have to be deferred for a day. Mr. T. Gogoi, learned counsel.
Taxation.
Technique. Does not object to the fair day. It's begin on 18 July. Prepare.
Sir, lordship, can you on 19 July?
No, 18.
My senior is out of station. Your Lordship.
We are directing you to argue, not your senior. You be prepared on 18th and argue the matter.
Okay.
Huh?
Have please, your lordship. Lordship, here in this case, we have been informed that private respondent has expired.
That Moina Bora.
That is counsel for the petitioner submit that private respondent number
13.
30 has expired. We'd like to take steps to bring legal aids on record.
No, Lordship, it's a dispute between husband and wife. Husband filed this application, wife expired. Most probably matter has become infactual. It wife too. Wife is still
Moina Bora. No, I think grandmother.
Huh? Oh, Lordship.
Grandmother.
No, Lordship is still survives, Lordship. The grandmother, according to her.
So why is she necessary? What is your grievance here?
Now, the complaint was lodged by this respondent number 13. Unbelievable. One number paragraph.
10.
Paragraph 10, Lordship, at page 10.
Who is the owner of the property?
Paragraph 5, it reflects that the petitioner is the at page 8. There was, after a long period of service on attaining superannuation, the petitioner permanently shifted to his present address and started to live with his wife and 2 children. Wife expired earlier. Thereafter, after her death, Lordship, second marriage was there.
What order are you complaining of?
The order is at page, Lordship. Annex 4, page 32. The effective order is at page 33, Lordship. The decision. After hearing the parties and much deliberation, the members of Koliabor Subdivisional Women's Cell unanimously decided as the second party respondent Sri Dilip Bora shall vacate the house of the first party. Aggrieved party Srimati Moina Bora within 15 days. Mainly, they are against this decision taken by the Women's Cell, Lordship. So The complaint was lodged by my,
Under what authority this order was passed?
seems to be, Lordship.
What order? What is this? Subdivisional women cell hearing?
It's an authority under the Social Welfare Department, Lordship.
Who is
But
for social welfare?
to my knowledge, Lordship, this displacement, Lordship, they cannot. Apparently, Lordship, it seems to be. But even then, Lordship, we have not received any such instructions.
Who is for social welfare?
We are appearing.
Preparing. Please obtain instruction to tell us under
On
what
the Lordship,
provision this. So we'd
they
like
have-
to know what is this cell, women cell? And what?
Women's cell, Lordship, there is a, by way of notification, it came, Lordship. But even the Lordship, I will place in the that specific query, Lordship. This is the notification, Lordship, I have, Lordship. May I place it before Lordship? In that notification, I have gone through, Lordship, that power is not given to them, Lordship. They have, I think, Lordship, they have exceeded their jurisdiction.
This is the State Women's Commission.
Lordship.
But this is not Women's Commission.
Lordship, they
It
is constituted under that notification, I think.
All right, you get your instructions.
Lordship.
On record.
Lordship.
Matter be posted after 2 weeks, enabling the respondents to complete their instructions with regard to the constitution and functioning of the constitution, functioning and powers of the
Subdivisional
women cell.
Lordship.
Which has passed the impugned order dated 14/3/2023, assailed in the present petition. Here, MS
C. Sharma.
C. Sharma appears for the writ petition.
May I get back that
Yes.
notification?
And petitioner submits that respondent number 13 has in the meantime, during the pendency of the writ petition, has expired. And therefore, she is also permitted to take proper steps, if so advised in the meantime. She was unmarried. That is what your petition says. Then who will you bring now?
Lordship, that is why I'm placing that most probably the petition has become infructuous. That's because the complaint was lodged by respondent number 13. She is no more. So matter ends there, Lordship, otherwise.
No, matter ends.
But regarding that instruction, Lordship, I will place it before.
No. Matter will not end there because this matter is not pending. They have passed an order.
Lordship.
So the question is whether this order is valid or invalid.
Lordship.
Yes.
Apply, sir.
Yes.
Lordship, in this case, although the respondent number 5 has filed the affidavit in opposition, Lordship, but copy was never served to us, Lordship.
Without serving a petition, how you can file, my lord?
Lordship, kindly see the notice, Lordship, annexed with the affidavit in opposition, Lordship. They have served copy only to the respondent authorities, Lordship.
Okay, my lord.
You serve him copies.
Yes, my lord.
Learned counsel to the
Kindly leave a
petitioner
contact number
submits that although an affidavit has been filed by the respondent, which respondent?
5, my lord.
Respondent 5.
I have received instructions, my lord. Can this may be granted?
Which is part of the record, but the copy thereof has not been served on the writ petition. So, learned government advocate MSM Hormone submits that she would like to. She has also received the instructions and would like to file an affidavit. in the meantime. Is this matter after 3 weeks?
Lordship. Obliged.
Lordship, this is a arbitration application. A substitute arbitrator is to be appointed against the earlier arbitrator, Lordship. This is the,
Who was the earlier arbitrator?
sir, Mrs. Nain Sharma, and earlier to that means Nain Sharma, there was a Colonel Goswami, Lordship. Initially, what happened, Colonel Goswami, due to ill health, he has resigned it. Ultimately, Honorable High Court has appointed Mrs. Nain Sharma. Nain Sharma has not done, could not able to award within 1 year prescribed. Both the party has given time for 6 months. That too was, they could not able. Then we have the lower court, lower learned court, they have extended time for 1 year, which was challenged to this High Court, and this High Court set aside the order of the High Court and requested to get appointed as a substitute arbitrator under Section 15.
Yes, Mr.
Lordship, we have filed an affidavit, Lordship. Now, we have stated that it should be from the panel. We have a panel, Lordship, that we have annexed, Lordship, or someone who is from the engineering background.
But in view of this amendment under the Arbitration Act,
12.5, that's not a surveying officer. That issue is pending before full bench of
maybe,
the.
but
But no stay order has been passed to that regard.
may not be, but which means that the provisions of this act is applicable. Provisions as on date are applicable, arbitration. What was this? 12. What was this section?
12.5 perhaps.
12. Yes, 12.5. Have you gone through the section 12.5?
Lordship, 12.5 is not applicable to my case.
Why?
Because my case is
Then you can
prior
then
to
get
the
someone
amendment
from
of
the panel can be
2015.
appointed, Lordship. That's objection is not there. Someone from the panel can be appointed, Lordship.
12.5.
Lordship, because 12.5 has come after the amendment of 2015.
Right.
But my case is very old, since 2014, Lordship. Then it is not applicable to me. However, sir, I am also agreed to for appointment of engineer or any arbitrator. There's nothing.
No, this will amount to a fresh appointment.
It's all definitely, it is appointment, fresh appointment. But under the old, prior to the 2015, Lordship.
All right. Mr.
GD Dhiman, sir.
GD?
Dhiman, DHIM.
Learned counsel for the petition.
Petitioner in person.
Petitioner in person. Mr. P. Chakraborty, learned CJC appearing to the respondents. The petitioner is before the court for appointment of an arbitrator.
From panel of the High Court, Lordship.
Stop. There was the petitioner in person submits that there was an agreement executed by and between the petitioner, the respondent and the respondents. Where is the agreement?
That has not been.
Do you have the agreement?
There was clause 70 of the GCC is the relevant provision. Lordship, I have a copy of that.
No, but the agreement is not here.
Agreement is not.
Then?
Sir, we have enclosed in first appointment, Lordship. It is not, but that is the only arbitration clause, Lordship. That is the agreement only.
Lordship, this is the clause.
This is the only one case clause, Lordship.
Clause 70, Lord. This is an affidavit in another case, Lord.
No, but where is the reference to the contract? Which contract?
That is mentioned in the main contract. Also.
So
That
where
is
does
there.
one get it?
But that is standard agreement that
We are passing an order at your request to resolve, appoint an arbitrator to resolve the dispute. And you are not willing to give us.
Then I'll submit the contract. So the one.
You submit and tell us what is the contract, what dispute. We'll have to indicate in the order.
Lordship, I'll submit the that agreement.
When can you do it?
Within a week, Lord.
Within 1 week.
But on
All right, after a week.
Fixed date kindly. So
Matter be listed again on, you tell us your date when you want it.
any date. So it October चल रहा है ना, August, September,
July.
July, May, July. On 30th, Lordship.
30th.
30th.
All right. So you take it on, you take it on first.
Lordship.
1st of August.
Lordship.
Matter be listed again on 1st of August, enabling the petitioner in person to bring on record the particulars of the contract agreement arising out of a contract agreement in which the dispute between the parties have arisen and for which an appointment of an arbitrator is sought for by filing the application. List on 1st August.
Obliged, Lord.
Yes.
Lordship, where the land of the petitioners were acquired by the National Highest Authority. And accordingly, Lordship, an award has been made, Lordship. And thereafter, Lordship, there is a dispute arising for the apportionment of the award. So definitely, Lordship, it will come under the section 3A of National Highest Authority. 3A.
3H.
Yes.
Arbitrator.
No, Lordship, it should be civil court. It should be referred to the civil court.
3H subsection
4.
4. So have you represented before the competent authority?
Yes, Lordship. I have already submitted the application.
Where is that?
Lordship, during the pendency of that, I have also approached Lordship. And otherwise, it is a statutory provision that should be automatically given to that particular.
You'll have to bring it to the notice of the competent authority that there is a dispute. Where is that?
Oh, yes. This would I am referring to. Lordship, carrying to the affidavit filed by the respondent, Lordship. Affidavit. It will not be clarified. The one person Lordship, actually that the land Lordship acquired by the National Highest Authority. This is the petitioner's land along with one co-partner. And now the co-partner he's saying that I have sold the land to him through a sale agreement. Lordship, only see the affidavit. Lordship.
Yes. No, first. See, you claim to be a partner.
Yes.
The land was acquired. You are entitled to compensation.
Yes.
Now the co-partner says no, there is no ownership. He has already sold the land. So apparently there is a dispute with regard to the title.
Yes, yes.
So under 3H,
yes,
if there is a dispute to title, it has to be referred to the competent civil court.
Yes.
Now where the dispute is there, or there is an existence of a dispute,
Yes,
how
there is a dispute.
how have you placed it before the competent authority? Have you intimated the competent authority?
Yes, Lordship, kindly see, yes.
Kindly read section 3H4.
Yes.
if any dispute arises as to the apportionment of the amount or any part thereof to any person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the principal civil court of original jurisdiction.
Now, in this, what has happened now?
Yes, sir. Because the co-partada, the son of the co-partada is saying that I have already sold the land.
Saying where?
Lordship, they have in the affidavit filed by the government, there is also document. I have also annexed in my petition. They submitted a sale agreement with me, showing that I have sold the land. Lordship, kindly see page 33. The application I have filed, Lordship.
But have you filed all this before the competent authority?
Yes, page 33 in my petition.
Yes. Who is the competent authority here?
Yes, Kala, Lordship. Kala, this
ADC.
additional deputy commissioner. Yes, sir. This is a absolute dispute is going on.
What does the affidavit say?
Yes, Lordship, affidavit. Yes. Yes, Lordship. Paragraph 4, Lordship, may I read? That the deponents beg to state that as per LA report, it appears that the parta land measuring 2 biga 1 kata 5 plus out of the land measuring 4 biga 3 kata 5 plus covered by that number so and so of village Garamari part 3 is falling in the alignment for acquisition of land of construction of NH Goripur bypass, and accordingly award number 385 was prepared and compensation amount of 1 crore 20 lakhs has been assessed against this award. In this regard, the circle officer Goripur Revenue Circle has submitted inquiry report of the aforesaid acquired land, stating that the land measuring 4 biga 3 kata 5 plus covered by that number so and so has been recorded in the name of Yasin Ali, that is co-partada, son of late so and so. Number 2, Moksed Ali, this is private respondent, Jobbar Ali as the partada. The acquired portion of the land measuring 1 biga 1 kata 5 plus out of 2 biga 1 kata 5 plus is under the possession of Jannatul Haq, late Yasin Ali, being the purchaser by executing sale agreement. So this is the main point, by executing sale agreement and giving undertaking which was duly notarized.
So there is an admission that there is a dispute.
Yes.
So it has to be referred.
Yes.
Under 3.8.
Yes.
Why is it not referred? His affidavit does not reflect that it is referred. Get it by what? Next week?
Otherwise, it can be referred. Since they have already filed affidavit.
That is what we want to find out.
Yes.
Yes, it can be referred, but whether it has been referred, affidavit does not disclose it has been referred.
So that observation may be possible.
What observation? It is filed on 1st of April. Okay, heard?
AZ Ahmed.
AZ
Ahmed.
AZ Ahmed, learned counsel for the petitioner, and MSM Bormon, learned government advocate, appearing for the respondent 5 and 6, MSK Pukon for respondent number 1. And Mr. A.C. Sharma, learned senior counsel, assisted by Mr.
G. Bharadwaj.
G. Bharadwaj, appears for respondent 7. The petitioner is aggrieved by the fact that the land which is acquired by acquired by whom?
National
Highway authorities. His due compensation has not been released by the competent authority on the objections raised by the private respondent number 7. It is submitted that the private respondent number 7 is represented before the authorities concerned to that the petitioner had already sold his share of land to the private respondent number 7, or you sold it to?
Yes, Lordship, of that aspect, Lordship, by a sale agreement. It is reflected in the affidavit.
By executing a sale agreement. Stop. It is submitted by the learned counsel for the petitioner that This agreement is not a registered sale deed and which is also admitted by the competent authority. Notwithstanding that, the competent authority has overlooked the claim of the writ petitioner claiming compensation in the matter. Stop. Learned counsel for the petitioner has referred to section 3H of the National Highways Act 1956 to submit that under the provisions of the Act, in case of any dispute, the matter has to be referred to the competent authority, to the competent civil court by the competent authority who is nominated under the provisions of the Act. Stop. Para. MS M. Borman, learned government advocate, has referred to the affidavit filed by the additional district commissioner and competent authority land acquisition officer, Dhubri. She submits that in the affidavit there is an averment that the land has been, the share of land of the writ petitioner has been sold to the private respondent number 7. Stop. Para. Mr. H.E. Sharma, learned senior counsel appearing for the respondent, submit that petitioner is not entitled to any claim as the land has already been sold to his client and therefore the authorities have rightly released the compensation. You have received the compensation?
No.
No.
It's not.
And therefore it is the respondent number 7 who is entitled to be paid the compensation. Stop. There are learned counsel for the parties have been heard. We have perused the pleadings available in the court. The relevant provisions of the National Highway Act have also been perused. Para. Section 3H.
Yes, subsection 4.
Within bracket 4 of the National Highway Act reads as under. Extract. Stop. The perusal of the affidavit filed by the additional district commissioner also revealed that at para 6 of the affidavit, there is an averment that the land has been sold by the writ petitioner to the respondent number 7. The para 6 of the affidavit is expected below. Stop. Para from the pleadings and upon hearing the submission, it is evident that there is a dispute between the petitioner and the private respondent with regard to the apportionment and obligor the title of the land. Stop. Provisions of section 3H4 is very specific and categorical, and under the provisions of the said section, the competent authority is required to refer the dispute to the decision of the principal civil court of original jurisdiction within the jurisdiction the land is situated. Since the statute mandates such disputes to be referred by the competent authority to the principal court of civil jurisdiction, this court is of the view that since the affidavit of the competent authority of land, what is that? Land acquisition.
Yes.
The district of Dhubri has clearly reflected in the affidavit that there is that land claims to have been sold by the petitioner, which is disputed by the writ petitioner. Its court is of the view that there indeed exists a dispute between the petitioner and the private respondent. So that view of the matter is the petition disposed of with the direction to the respondent number.
Yes, Kala, it is competent.
5.
Yes.
Namely, the additional deputy commissioner land acquisition branch Dhubri within bracket competent authority under National Highways Act 1956 to take necessary steps if not already undertaken in terms of the provisions of section 3 capital H within bracket 4. So the steps, if not yet taken by the writ petitioner, by the respondent number 5, will be undertaken within a period of 3 weeks from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed of in terms of the above direction. That's all.
I know.
In the year 2009, my lord. In the month of October 2023, he has applied for mutation, my lord. The concerned circle officer has taken hearing time to time, my lord, but the petition has not been disposed of. Accordingly, my lord, the petitioner submitted representation in the month of April, my lord, but the concerned authority has not been responded. Therefore, he has again approached the district commissioner, my lord, by filing his representation, but that's also not
Get
responded.
instructions here. See, what is the status of the representation?
I will.
Heard counsel for starting. Ms. F. Sharma, learned.
Respondents
Cabinet
3 and 4, madam.
Appearing for respondents 3 and 4. Petitioner submits that his representations filed before the district collector seeking redressal, his grievance, seeking mutation of his name in respect of the land that is purchased have not been disposed of. He being aggrieved, he is approached this court. Whereas Leonard Government Advocate, Mr. Sharma, will obtain instructions in the matter. And let the matter be listed on. Can you get it on 29 July? 29
Extra
July,
copy.
in order to facilitate the learned Government Advocate to obtain the instructions, the extra copies be furnished within the course of the week. Sufficient extra copy.
Obliged.
Obliged.
Lordship, I have received the instruction, my lord. I have.
What is the gist of this instruction?
Lordship, may I kindly say on page 3, Lordship, I have marking there.
Yes.
He have stated the details of that case.
Yes. I do not know what actually, whatever you stated, that is it. That some amount was required to be paid, but without completion the payment in terms of the agreement, you have occupied the house and you have owned the.
My sole contention was the jurisdictional circle officer does not have the jurisdiction to decide this issue. There is a competent court of civil jurisdiction.
You're quite right, but.
But so far as.
But what do you address? What do you say in respect of these the statements made by the respondents that there was an agreement, you were supposed to make some payment that has not been paid?
So far as the agreement part is concerned, there was an agreement. We have made some payments and some payment was left. That is one part of it. If the circle officer comes in and issues a notice, so Mati Kinabesa Hamno Hundred, that's it. Competent court
No,
of
but
civil jurisdiction.
if an officer of the state makes an attempt to sort out the difficulty, why
My
do
lordship,
we
that
question the
should be
jurisdiction?
within the powers.
No,
conferred upon
that's
him
all
when-
right, but why don't you settle the payment and complete it?
We are ready and willing. Right now, we are ready and
Give
willing.
give a date and
Ready and willing.
sort it
But what I was on is that the way the powers are exercised
We'll examine that,
to
but
come
we
into,
want to know.
we'll make payments. We'll make payments. What you fixes it, we'll make payment.
Lordship, my lord, that the notice was given, my lord, the petitioner who was removed the, my lord, the respondent number 5 from his property. That's why, my lord, this notice was given. It is not regarding that.
Nothing at all.
My lord, he possesses the,
serve
the
copies on
specific
the-
money stated.
you
But he have never been stated in the, my lord, the writ petition.
You serve copies on respondent number 4
Lordship,
by Dusty.
watch.
Then we'll hear the matter again.
My only contention was the agreement says at the time of registration, the balance will be paid. If someone has a difficulty with the agreement, it can be two things, either for enforcement or for cancellation. That is a civil court. Now, again, I'm saying we're ready and willing to
Now,
pay.
registration of a land,
Sale deed.
sale deed,
Sale deed. That's
will-
page 23.
may also be understood to be within the compass of Mati Pesa Kinar Hompoko.
That has nothing to do with the circle officer intervening for enforcement of a contract or for cancellation.
No, you say that there is no dispute and he
There's
is
no
not
dispute.
necessarily interfering.
Absolutely.
So let the steps be taken on respondent 4 by Dusty.
Not sure.
You take by Dusty and let the respondent 4 appear.
We'll settle
the
it.
matters.
That's what we wanted all along.
Heard learned counsel for the parties, the instruction received by the learned government advocate placed before the court reflects that the respondent 4 who was the owner of the house in question and whose late husband had entered into an agreement and with the late husband of the respondent 4, an agreement was entered into by the writ petitioner for payment of for purchase of the property after due payment as per the agreement. Stop. However, after about an amount of rupees 11 lakhs being paid, the balance amount has not been paid. Meanwhile, the husband of the respondent 4 expired. And as per the instructions received, the respondent 4 was driven out of the house forcibly and illegally by the writ petition. Stop.
Our stand is we paid 29 lakhs.
The learned counsel for the writ petitioner disputes the claim and submits that if there is any dispute with regard to the title, then the circle officer does not have the jurisdiction in terms of the Assam Land Revenue Regulation 1886. He further submits that an amount of rupees
29 lakhs.
29 lakhs has already been paid, and they're willing to pay the balance amount on any date that the respondent number 4 on any date as this court may direct. Stop. Sarah, this in this matter, the notice have not been issued. Nevertheless, we permit the writ petitioner to serve copies on the respondent number 4 by Dusty, an advance copy, and file in a city. Stop. Let the matter be listed thereafter on 5th of August or 7th of August, and a copy of this order be marked to the office of the government advocate for onward communication to the office of the deputy commissioner, who will ensure that a copy of this order is also served on the respondent number 4. Can you do it? Through the circle office? Through the circle office? So that the orders passed by the court are also communicated to the respondent number 4. This again on 7th August.
Interim protection continues.
Lordship, interim protection, I have
Interim
an
for what?
objection, my lord.
What
I have an
interim?
No further
objection.
proceedings.
This is the, my lord, only because of the application filed by the respondent number 4, my lord. My lord, the petitioner asked to appear before that.
So status quo as on date?
Lord.
Let status quo be maintained by the.
Already been, my lord, he was the possess that property, my lord, he was evicted from.
No, if he's willing to pay, if the respondent.
That is,
for
my lord,
agrees-
we have nothing to say regarding the payment of this. My lord, only the petitioner is the remove the petition or respondent number 4 from his property, her property. That's why, my lord, this
Or
notice was
if the
again.
respondent 4 appears and says that, yes, I am happy with the money received, etc., etc.
That is different, my lord. We have nothing to say regarding,
right.
my lord, that his agreement in for the sale of the property.
We are marking a copy to you. You may send it to the office of the DC for being served on the respondent 4 through the circle officer, so that she may appear before the court.
My lord, that I have, my lord, that instruction, my lord, the cabinet.
No, you keep it. You'll get misplaced. Might get misplaced.
Let me file an affidavit.
You file your affidavit.
Lordship with the status quo order.
Status quo. Till 7. Yes, who appears for the what is this?
On the last occasion, Lordship was pleased to allow us to go ahead with the auction sale, and the auction sale had was successful, my lord. So now, within a period of 30 days, they have to make the complete payment. So here, the auction sale had happened on 8th of this month. So on 8th of August, it will be complete 30 days. So can it come up after that? Now only the thing of apportionment is left.
Apportionment of the claims.
Yes.
Yes. Between us and the respondent number 2. Because my grievance is
What is the amount received in
The in this matter, my lord, 2.11 crores.
And what is your claim?
Our
What is the claim of the provident fund?
My lord, the claim of the provident, my lord, I am a little handicapped with that.
I
I'll come up
believe
with
it's
the
1 crore 53.
1 crore something like that. The exact amount I'll.
Plus maybe some interest charges, etc.
All right.
And in the other matter, my lord, the auction sale had happened on 9th of July.
It is submitted by the learned counsel appearing for the Assam, what is this?
APPFO, Assam Tea Employees Provident Fund
Assam Tea
Organization.
Employees Provident Fund Organization, that pursuant to the liberty granted by this court, the auction in connection with the tea estate, the auction of the tea estate in connection with WPC 3366 of 2024 took place on
8/7/2024.
And it is submitted that the formalities will have to be completed, and therefore the same are required to be done within 1 month, 30 days from the date of the auction taking place. He therefore submits that the matter be listed after 8th of August.
Okay.
So, insofar as the other matter is concerned, the auction took place
9th
of the tea gardens in respect of WPC 3355 of 2024 on 9th. Accordingly, let both the matters be listed on 12th August. Mr. Ganguly appears for the writ petitioner, Mr. Kolita for respondent number 1.
The order passed earlier may continue. The interim order. So that was not.
What
to
is the
disburse.
interim order passed?
Not to disburse, not to disburse.
The interim order passed earlier will continue till the next date fixed.
But you can be on 14th with the matter.
14th.
14th of August.
14th of August. All right.
Public.
Deeply.
Ms. G. Hazarika for respondent number 5. Mr. Hendik for respondent number 3.
May it please your lordship. Lordship, I'd like to apologize. My senior was here, but however, he had to leave again for court number 1, lordship. Lordship,
At least next week,
lordship.
at the request of counsel for the petitioner, the
Lordship.
matter be listed after a week.
Lordship, could it be recorded that the earlier order that the interim would be considered on the next date? Could it be recorded?
They are not necessary to report. Next week.
Much okay.
Yeah, please a lot. Lordship, in this incident matter, the respondents were supposed to file their affidavit, which they did. We have received a copy. Lordship may allow us 3 weeks time for filing the reply.
Counsel for the petitioner submits that he'd like to file a rejoinder affidavit phrased for 3 weeks' time. A rejoinder affidavit to the affidavit filed by the respondent. Mr. S.S. Roy appears for the respondent. CGC appears for the respondent. List after 3 weeks.
Much obliged.
Obliged.
Yes, what is the stage?
Scan copy of LCR and status report was already received, and on last occasion you lottery.
Roughly pursuant to the last order, that Rossip has fixed this matter after 4 weeks, last occasion, because at that time charge was not framed. My lord. I have checked the
Charge frame today, by
my
now.
lord, that report is not here, my lord.
Why is not here?
Not here, because it was not called for in last occasion. No, last occasion called for. The status report may be called for.
Okay. Let the status report be called for. Status report in respect of the proceedings before the Court of Additional Chief Judicial Magistrate Kolkata in connection with what is the case number? PRC number 1420 of 2023. The call for shall be listed after 4 weeks. Interim bail will continue.
Interim order pass earlier, it will continue.
What is that interim order? Bail.
Petitioner has submitted already bail bond lottery as per the honorable court.
He was in interim.
You are on interim bail.
Yes.
That's what we said. Interim bail will continue. Mr. Biswas for private respondent.
Yes.
Your objective.
Lost 2%.
So expeditiously try it.
I leave it.
What to do?
Your lordship, the call for the status report.
Yes, that will be after 4. Disciplinary proceeding.
Yes, ma'am. Your lordship has, I have concluded my argument. When my respondent was also have concluded only some clarification was sought for in regard to the record. They have filed an additional affidavit, but that was already a part of the record.
But when was the hearing concluded? Or when will we hear you?
Yeah, then coming Tuesday. Then. Because
We'll have to refresh our memory.
yes, coming Tuesday.
So let us have it in August.
I'll be not be available from 2nd of August till 14.
We'll have it after 14.
Well, may I pray any day before 31st of July, because this person has already retired and it is a whole litigation of 2015.
No, not before 31st. We can have it in the first week of August if you want, but you are not available.
Yes, ma'am. Then
We can
we'll
have
have it on, see, if you're subject to your lordship's convenient.
On 20th.
On 20th of August, it will be Tuesday.
Let the matter be listed on 20th of August.
20th.
As agreed to by the learned counsel for the parties. The relevant records pertaining to the disciplinary proceedings, the kept available in court by the respondent counsel for perusal if the need so arises. 20th August.
Obliged.
Yes.
Lordship, my senior is on another court, Lordship. Kindly fix the matter August 1st.
Why, what review?
Lordship, there is 7 judge judgment is there. When the arbitration is already commences, no court can interfere. It cannot. I have already at page number 3 is the final. Page number 3 kindly see it, Lordship. Page number 3 of C, para 6 of 7 judge judgment. It is highlighted, Lord. No court can start it. They can challenge after section 34 after making of the award. Page 3, my lord. Sir, it is in advanced stage. Arbitrator has, everything has been given, hearing has been also taken place. Only one hearing is left over. Now, at this belated stage, they come before the court and obtain ex parte stay.
You know, where is the order seeking review? Where is the order which you have sought review for?
I'm not aware of this.
Why are you not aware? You're holding the brief.
I'll have to take instruction from the.
What instructions? You have to open the brief and read it. Read it. Why have you not read matters? When is your matter fixed? The other matter?
On 1st of August.
So we'll keep it on first.
But on this bench only, because last many benches I have attended. All the honorable benches have agreed with me. Even the other party has taken always the time.
We are fixing it on first.
On with this bench, with yourself, Lordship, please, Lordship, please, Lordship.
No, then we'll have to. We can't fix it like
Lord, just kindly add it half for deposit, and it will be listed again. Please, Lordship.
Lordship.
It is Lordship. I used to come from Chandigarh, Lordship. Please kindly.
No, which order you are seeking review of?
Lordship. I'm sorry, I was in a matter for personal
That's
appearance,
all right.
number 7, Lord.
But you must tell your juniors to open the brief, and they are scared that the senior will be unhappy if the brief is open.
Lordship.
Where is that order?
Lordship. Order is at page 10.
Page 10.
Page 10.
Then what review are you seeking?
Lordship, at page 11, of course, it is written that B. Chakrabarti Lan has fairly submitted, he has no objection in a new arbitrator is appointed. But I did not make a given consent to Momita Bora because no communication was received from the petitioner here in Lordship. So they are in dark, Lordship. Now, the case is that, Lordship, this Momita Bora was also the secretary of the earlier arbitrator, Lordship.
No, you have not objected to a new arbitrator.
You know.
So the court has appointed a particular arbitrator.
But no consent was given from the respondent themselves. Because only the I, as a personal capacity,
Mr. Counsel, your consent is not necessary. This is an order passed by the court.
Necessary, Lordship, kindly allow me to explain, Lordship.
Yes.
This he was the secretary of that particular earlier Mr. Late Manoranjan Goswami is appointed an arbitrator, and she was the secretary of that arbitral tribunal, Lordship. Now, she has also appeared in several cases against us, Lordship. More particularly, one
secretary means she's what? She's an advocate.
Advocate, Lordship.
Lordship, she is an advocate, and she is the member of arbitration council, Lordship.
No. Then how she was the secretary?
She was the secretary of the arbitral tribunal, Lordship. Now, she has also passed an award in which the award value was 25 lakhs. The award was 1 crore against us, Lordship. So, Lordship.
That was different.
Once beaten, the Lordship.
No, who submitted the name here?
The petitioner, that is hearing.
What is the
My
stage?
friend submitted.
What is the stage of the arbitration now?
Oh, it has to be started from
the state of the arbitration is that all the statement of case of both the party, pleading in both the party, reason of both the party submitted. One hearing has also been done.
No, Lordship.
Only one or two hearings. Lordship,
because we filed an objection, she has stated, Lordship, they kindly see the objection, her reply to the
Lordship,
objection.
there are a lot of decisions with me of the 2020 Supreme Court also. They cannot interfere it because they have agreed at that time, Lordship. They can file an objection in section 34.
Now this
whether Lordship,
this order was passed on 21/12/2022.
Okay.
You waited for more than
no, Lordship.
You waited for 6 months to file the review.
Yes, Lordship. We filed it.
Why? You should have filed the review then and there itself immediately. If the appointment of the arbitrator is causing so much of heartburn.
No, Lordship, we filed in February, just after 2 months.
No.
Order is of December, Lordship.
No, who filed the review? Union?
Yes, we filed in February, Lordship, 14 February 23.
No, it says 27 June. That's what the filing stamp says.
Lordship.
Review petition 83.
Lordship.
It was filed on 27th of June.
Have to check it.
You check it up. It's there. Why you waited for so long?
May I read some, I have some noted one, 2, 3 paragraphs, small of 7 judgment. May I read it?
Let the file come.
Lord. Sir, one more submission is, Lordship.
Yes.
My learned friend is talking about that other award. In that award, they also challenged a writ petition before other court. That was also dismissed, and ultimately the award was passed. Again, now they are doing this. I don't know, their dilatory tactics is going on, which is a very serious matter for the, as decided by the.
Lordship, it was
All the
received
time they are
received
doing.
in February, but perhaps it was line defective because it says the file has been returned on 27/2.
Whatever it may be, from February to June, nobody is bothered that there is a defect which needs to be removed. Then
Because this is on 22, Lordship. 22/02.
may have been received, but who is supposed to check up? It is for the council to decide.
Of course, it's lawyer.
So the filing date has to be reckoned from the date the registry records that it is filed,
Lordship.
not on the date it is received.
That's true, Lordship.
Then what remains now?
But Lordship, the background of the case has also has to be, and Lordship, in that this full bench decision of the SBPP case, Lordship, it has been stated that mere intimation is not enough. The respondent has the right to receive notice, Lordship. That has been stated. Mere intimation is not enough.
You are asking for a review of the order. We have to go by the order. This was an inter-party order.
Lordship. But the fact remains that the no notice was personally received by the review petitioner hearing.
Then you go and file an appeal. You file an appeal against this order.
Lordship,
What is the ground for seeking a review?
they have not heard, Lordship. Though I appear, Lordship, it is given that there is a consent, Lordship, I can read paragraph 3 and 4 of the review petition.
So what are your objections?
Lordship may appoint anybody from the panel of law.
What are your objections with
Lordship,
respect of this?
Lordship, she was a counsel in against us in three writ petition. One is particularly in the same division, Lordship, which is pending, Lordship. And in view of 12.5, whether she is will be able to appear, Lordship.
In view of 12.5?
Of the Arbitration Act.
Huh.
Whether she will be, she has to give a declaration that she has not given that. That is mandatory, Lordship.
Arbitration Act.
Lordship, kindly. There is the provision of
Lordship,
12.1.
again 12.1 is not applicable to me.
Let me make
That
the
is
submission.
after
You will get your chance.
2015. Okay.
You will get your
ठीक है.
chance.
Okay.
The 12.1 was amended in 2016. The order passed by the court is in 22.
Lordship,
12.1
this contract originally when came in the arbitration is prior to 2015, Lordship.
maybe, but the mandate of the act with effect from 12.1
Yeah.
came in 2016, so it has to be followed.
But-
So any arbitrator has to give a declaration under 12.1.
Even if it is agreed with, then I would like to say something also. Same arbitrator given award against his writ petition file that was dismissed. They never objected that person, that lady, saying that this type of application has not been given. Same thing is the reiterated. Or Lordship, one thing is there.
No, may not be, but today if they have raised an objection, then we need to look, you have to find out whether this objection is based on any provision of law.
One thing, once Lordship said, Supreme Court 9 May 2023 said regarding this 12 say that an arbitrator may be challenged only if the circumstances exist that give no right in right as to the defendants within 15 days, Lordship. There is a limitation. 15 days, but they have come after so many months before this court.
Lordship, can you also Paris 16.2 also? Even after participation, I can raise the plea.
So that is jurisdiction.
Lordship.
We are on the ground of challenge of the arbitrator.
That will be
One.
related, Lordship.
And 2. 2 is also applicable.
Reason. So what's I mean appearing before any other arbitrator? And the name comes from my learned friend, Lordship.
Hmm?
The name suggested was from the.
No, may have suggested, Mr. Dhiman.
Lordship, yes.
If you look into section 12(1) and 2,
Lordship.
there is a requirement for the arbitrator to disclose, to make certain disclosures. Has it been done?
Lordship, one submission is that that has to be disclosed within 15 days.
Under which provision?
And that I'm coming, Lordship, that I'm coming to 12(13)(2). Failing any agreement referred to in subsection 1, a party who intends to challenge an arbitrator shall within 15 days after becoming aware of the constitution of the arbitrator.
You are reading from which?
The Lordship,
13(2).
section 13.
13(2).
Two,
But first is to go
subsection
to 12(2). First is to go to 12(2).
No, 13 to
13 subsection
this
2.
is with regard to the procedure.
They challenge procedure.
No. They are challenging the very arbitrator itself.
Procedure for challenging the arbitrator. They are challenging the arbitrator, Lordship.
See, 13(1).
12 to cast a duty upon the arbitrator himself.
I'm reading 13, Lordship, not 12. I'm reading 13, sir. One.
Yes. You should have raised this issue before the tribunal.
Yes, Lordship, we have raised, Lordship. Lordship, can you see my rejoinder, Lordship? Page 31, Lordship. Page 31. This was submitted in January 27, 2020.
What responses come?
Lordship. Page 34. And that part has been dealt at page 35. Read from further. Further, it is pertinent to mention that the respondent has submitted a letter dated so and so, bringing in some allegation against the arbitrator. With respect to such comments made by the respondent, though at present I would not like to make any comment on those allegations, but I would like to state that instead of doing this kind of activities, the respondent should be more focused on the case and try to submit all requisite documents on time before the arbitrator and contest the case. in the best possible way. Also refrain from sending some document through all means of communication. Any communication to arbiter also should be sent to the claimant and vice versa. Lordship, this has been dealt with the provision of section 12, Lordship.
That this, how it arose, why she is so, because on the first hearing, she said, I have nothing to do with this claimant, I'm going with the case. He is open his minded. And that's why the case was proceeded to filing several documents to her.
Those things are
What
not
is the award?
reflected.
What is this award at page 36?
This is an award by the same arbitrator against us in a separate, in a different proceeding.
So how does it matter?
Lordship, Lordship here, the claim was one value was 27 lakhs and the award was of 1 crore, more than 1 crore.
Whatever it may be, you are entitled to challenge it.
No,
under
no,
34.
my friend appeared in that case.
No, no, have you challenged this under 34?
Oh, this is under challenge. This is under
Then
challenge. This
how
is
is it
under
relevant?
challenge.
Lordship,
This is under challenge.
this has been stayed
This
by
is
the
only a supportive
this has
document.
been stayed by the Supreme Court, Lordship, on the May 23.
With this award?
That award which they have challenged, that is stayed by the Supreme Court. I'm having the judgment with me.
That's all right. So you are now filing a review.
Lordship.
You are not really filing an application challenging the appointment.
Lordship.
You are filing a review on what ground?
On the ground that we have not heard.
The order doesn't say so.
Lordship,
Order is very clear.
Lordship, can you peruse the Lordship paragraph 37 of the SBP case, Lordship?
Hmm. You come to page number 5 of your review petition.
Lordship.
Page number 5, clause capital B. You said the arbitrator is being in professional relationship.
Yes, Lordship.
What profession, in what capacity?
Means she's appearing against us in 3 of the proceeding, Lordship.
How can it be professional relationship with MES? It is appearing not on your behalf, against you.
Against us.
Then?
Against us.
So why are you making this statement in professional relationship? Are you in professional relationship with the respondent?
In a professional capacity, Lordship. Lordship, can you peruse paragraph 37 of the SBP judgment, Lordship? Thirty-seven. May I read, Lordship?
1 minute. Yes, 37.
Paragraph 37.
Yes.
It is the fundamental to our procedural jurisprudence that the right of a no person shall be affected without he being heard. This necessary imposes the obligation on the Chief Justice to issue notice to the opposite party when he is moved under Section 11 of the Act. The notice to the opposite party cannot be considered to be merely an intimation to that party of the filing of the arbitration application and the passing of an administrative order appointing an arbitrator or arbitrator. It is really the giving of an opportunity of being heard. So that opportunity, Lordship, has not been, because they personally have not received any notice, Lordship. So that opportunity they have been, though I represented it as a CGC without any instruction, Lordship. I thought that what she may be that later on the background of the case, I came to learn about all those development, Lordship. Now, question comes whether Lordship in a arbitration petition, whether review will lie, Lordship. In that case, I will be relying on a decision, Lordship. 2019 3SCC page 203. The judgment is perhaps in the record, Lordship.
No. There is an interim order.
There's interim order staying for the proceeding.
Then why did you not say that?
And it has been fortified by Justice Borua also, Lordship. Initially passed by Justice S.K. Mehdi.
Record has not been called for. This
Not called for.
arbitration petition 4.
No.
Okay. The matter be listed again on, when is the other matter?
On 1st of August.
1st of August. And on which date? The registry will list this matter along with the records of arbitration petition 4 of 2014 within brackets since disposed of. What is the judgment you are relying on for
review?
Support of review?
2019 3SCC page 203.
2019?
19 3SCC
Yes.
page 203. Party's name is 203. Party name is Lordship Municipal Corporation of Greater Mumbai versus Pratibha Industries Limited.
Paragraph?
Paragraph 8 and 11. Says that being a court of record under 215 Lordship has the power to review even in arbitration proceeding.
May I also cite one citation?
Yes, yes.
There is a 2015 SCC 706 Deep Industry Limited but ONGC.
Para?
Para Lordship 15 and 19. And Lordship then 7-judge judgment and para.
You give a list to the court master.
Oh, Lordship.
Both parties.
Lordship.
Yes. List this matter again on 1st of August along with when order. Yes.
Obliged.
Lordship, this is an online request.
Yes, yes.
Yeah, I appear for the petitioners, my lords. I'm grateful to my lordship for allowing me to attend the hearing online.
Yes, yes.
Lordship, this is a GST matter. It challenges the notification issued under section 168A of the GST Act, extending the time limit for passing orders for the year 1819 and 1920, and the show cause notice and the OIO as being time barred. On the similar issues, my lords have already issued notice and granted stay, and the matters have been kept on 22nd.
What is your ground for stay?
That does not exist any force majeure. Section 168, there is a precondition that in case of force majeure situation, the government can extend the time limit for passing the orders, while notifications does not specify any force
All right,
majeure.
heard. May I learn counsel for the petitioner and who's for the respondent?
I'm
Mr.
appearing
Borua.
for respondent number 2 and 5, my lord. It's the GST, my lord.
Mr. H. Borua appears for respondents 2 and 5. None appears for respondents, the other respondents. The petitioner before this court is aggrieved by the notification. Which notifications? 9 and 56.
My lords, 9 and 56.
9 of 2023 -CT dated 31/3/2023 and notification number 56/2023 -CT dated 28/12/2023. Issued by the respondent number 1 under the provisions of section 168 capital A CGST, extending the limitation and thereby completing the issuing demand notice to the petitioner and thereafter passing the impugned order imposing GST, imposing taxes, penalty and interest on the writ petition. By which order? 29-4.
29-4, my lords. Annexure 14.
Order dated 29-4. The counsel of the petitioner has challenged these notifications on the ground that they are that the grounds force majority will not cover the COVID pandemic situation, which was used as a ground for extension of the limitation and thereby completing the issuing the demand notice and passing the impugned order. It is submitted that perusal of the provisions of the Act, perusal of the provisions of section 168 capital A reveals that there is no that the action of the respondent authority in issuing the demand notice and passing the impugned order is contrary to the provisions of the Act, and thereby the impugned notifications dated so and so are contrary to the provisions of law and therefore are required to be interfered with and set aside. So, learned counsels for the respondent submits that learned counsel for the petitioner submits that the question of the constitutional validity of section 16(4) of the CGST is also issue raised here, and the matter is presently pending disposal before the apex court in Tunjay Kumar versus Union of India in SLP number so and so. So, learned counsel for the respondent submits that there are similar matters fixed on 22nd of July. Therefore, submits that this matter be listed along with the bunch of writ petitions on 22nd of July. Stop. Accordingly, let notice be issued returnable on 22nd of July. Respondents are permitted to complete their instructions and file necessary affidavit, and the writ petition be listed along with the other bunch, connected bunch of writ petitions. Do you have the numbers? One or two numbers?
PC 3285 of 2020.
3285.
3285 of 2020.
2023.
24.
24. Another connected bunch of writ petition. And till the next date, let there be no coercive action taken against the writ petition. List accordingly, since the standing councils enter appearance, notices are waived, however, extra copies be furnished within the course of this week. Within 2 working days, you serve copies immediately.
Maybe.
MS
M. Deka, Lordship, one
M.
minute,
Deka
Lordship.
appears for 1.
Lordship, our name is not reflected in the cause list, Lordship. Kindly
You
reflect.
appear for central GST.
GST,
Appears for central GST. Let the names of all respondent councils be reflected in the cause list by the registrar. List accordingly.
Highly obliged.
Yes.
Obliged.
Yes.
I have one item in part 2, my lord, item 43. But main problem is that my lord, I may not be available tomorrow, my lord. Can it be taken up, my lord, in the next week, my lord? Not today, tomorrow and day after tomorrow, my lord.
Next week already. 43. Next week already. It will remain in the list.
Yes, yes, my lord.
Yeah.
Obliged.